Lord. My Lord, with consent of the other side, my Lord, I beg to mention item number 55, my Lord. Due to my personal difficulty, I have to leave the court, my Lord. After 1 week, my Lord.
You're for the petitioner.
My Lord, I am for the petitioner.
Petition. 55 with the request of Mr. K.U. Ahmed and preferred to be listed after 3 weeks.
Right.
May I please, Your Lordship? I beg to mention with the consent of petitioner, my Lord, item 34, my Lord. I have prepared the affidavit, my Lord. Not come time, my Lord, some health issue, my Lord. So 1 week time may be allowed.
Who's for the other side?
I am the for petitioner. And
You are the-
my Lord, in interim order, all be considered. So date may be fixed. Unreturnable date. Today is the returnable
And
date.
within learned counsel appearing to the respondent. Praise for further
2 weeks.
2 weeks time. File an affidavit.
Date may be
Mr. Ritali, there is no interim order.
interim order considered today, my Lord.
Was to be
Returnable date.
considered. Submit that interim order was to be, prayer for interim order was to be considered today. Before he submits that, a matter to be listed on a fixed date. It's again on 13th June.
I am
Lord.
present.
May it please, Your Lord. My Lord, in item number 10, the contempt petition, my Lord, there has been change of guards in the office of the contemptors. And therefore, we filed an IA for doing some changes in the cost item. The IA has not been listed, but this has come. The contempt petition has come. Your Lordship permits us to bring the IA today, my Lord, it can be taken up. Otherwise, if Your Lordship fixes some other date.
It's up to you if you can, but you'll require some mention memo, something to get it.
Yes.
How will you get it?
Add to, if Your Lordship permits. Otherwise, on Monday.
Monday. All right, Monday.
Okay.
Item 10
Item 10.
be listed on Monday. As it is submitted that an IA for impleadment
Implement of
of
necessary.
new respondents have been filed, which is however not listed. Then let it be on Wednesday. Monday may be short.
28.
28?
Yes.
It's on 28. Along with the IA.
Oblige me.
Ma'am, please, the Lordship, with the consent of the other side, I beg to mention item number 23, Lordship. Lordship, the matter may be taken after 3 weeks, Your Lordship.
23 at the request of counsel for the respondent, matter stands deferred after 3 weeks.
My Lord, I am for the petitioner. This is a pension matter, my Lord. I am putting for only date, my Lord. Date may be
The point, you are a 3 weeks.
16, 17.
16, 17 will not be 3 weeks. 20,
My Lord,
20, 20.
depend.
It's on 20.
Within the petitioner, my Lord, I beg to file a 45, my Lord. In this case, they filed an additional affidavit, my Lord, on first week of May, my Lord. They filed an additional affidavit, my Lord, first week of May, my Lord. So I will allow some time, my Lord, 4 weeks time to reply, my Lord.
4 weeks is too short.
3 weeks, my Lord, 3 weeks, my Lord.
45 at the request made by Mr. S.K. Mehdi, learned CTC. Matter stands deferred to be listed after 3 weeks, as it is submitted that the respondents would like to file reply to the additional affidavit filed with the petitioner.
So can it be on
You want
20?
the date?
Yes, Your Lord.
It's on 18th of June.
No.
18th of
All right.
Yes.
Okay. Well, the Lord, just number 19.
Yes. What is the
This
item
one
number?
30. I think
Item
item
30.
number 2. Item number 2.
Item number 2.
Yes, my Lord.
Yes. What do you want?
30 May, I want. On the list of that 30.
Why?
My senior out of business only.
Who is your senior?
Aravind does.
30 May is not possible. It will go in June, at least after 3 weeks. Yes.
Please, Your Lordship. Lordship, item number 4, Lordship. It is foreigners case, Lordship. It is division bench matter, Lordship, and it is already listed before the division bench on Monday, Lord. Item number 4, Lordship, foreigners matter, Lordship. It is a division bench matter, Lordship. You wrongly listed before your Lordship.
I'll take that. I'll open it. 1 minute. Item number 4.
Lordship.
Itu ayo পুরো নাম ফেলে গেছে। ফেলে গেছে। View petition কিমান? হা? এইটোৱেতো item 4 আৰু বেলেগ কি? এই চাওক না। It is shown something, but some other file has come.
Lord.
100. Item 4. Item 4 has been wrongly shown in the list as review petition 116 of 2020, when the case records reflect the number as review petition 116 of 2022. Registry to make registry to verify and list the case appropriate. This case is not listed. Your review petition shown in the list
Lord.
is not before the court. What is before the court is not shown in the list. Right?
Outlet.
With a consent of the Arbitrator, I beg to mention item number 37 here. Learned counsel for the petition is out of petition, Your Lordship.
37 at the request of the counsel for the petitioner.
Yes, yes.
Matter stands deferred to be listed after 4 weeks.
With the consent of other side, I beg to mention item 25.
Item
25, my lord.
25.
An affidavit was to be filed, my lord. We will file it, not a week's time, maybe.
25
25.
for the counsel for respondent, prays for 3 weeks further time. Yes, any objection?
I need one date may be fixed on 5th of June.
5th of May.
June.
We listed after 2 weeks.
Maybe 13th.
Huh?
13th of June.
13th of June.
Hello.
13 will not be 16th of
Lordship, item number 5. Pursuant this honorable court's order, my lord, I served the order copy to the P&D department. It appeared, my lord.
Instructions are awaited and
We have not even called for it. Wait for your turn. You wait for your turn, item 5.
Time. Wait for time.
item 1.
This matter, the additional affidavit you have filed it yesterday. Lord, it has perhaps not come on record.
We have filed it yesterday.
Yes, my lord.
Additional affidavit. Right. Mr. H. Gupta, learned CGC, appearing for the respondent, submits that the additional affidavit as permitted to be filed by the court earlier was filed yesterday. Date to be. The same, however, is not connected to the case record and had to be listed after 1 week. Registry to trace out the affidavit stated to have been filed and connected to the case record.
Item 3.
Yes, Mr. Bhutto.
It is your lordship. It is the non-payment of area salary, sir.
Very
Last
clear, sir.
based on
Who's
Mr.
the
P.
who
Gogoi,
appeared? Health Department.
Health Department, P.
Where is
Gogoi.
the direction?
That was there, looking, they were to make payment prior to the last financial year. The matter was fixed on 20th of March. In the medium, they will make the payment. They would have been made the payment.
Yes, Mr. Bhuya.
Lordship, my humble apologies. Can this matter be taken after some time? Actually, I don't have instructions regarding this matter.
Get instructions.
Lordship, after some time, okay.
No, get instructions. We'll take it up on 28.
28.
Get instructions as to why the order was not complied with. Mr. T. Boto, learned counsel for the petitioner, and Mr. M. Bhuya for the respondent. Mr. Bhuya is permitted time till the next week, till the next date to obtain instructions as to why the directions contained in the order dated so and so, passed in WPC so and so, has not yet been complied with. Placed accordingly.
Obliged, Your Honor.
28.
28. Much obliged.
Item 5.
You want some time?
Lordship, yes.
Say that clearly, Mr. Z. Hussain for the petitioner, and Mr. Your name?
AK Ghosh on behalf of Mr. Arthur.
A.K. Ghosh appears on behalf of Mr. S. Dotto for
Yes, this one number 2.
respondent number 2. We praise for 4 weeks time to file his affidavit. The matter. List again after 4 weeks.
Left.
Yes.
Similarly to non-compliance to the order dated 13/3/2023. Last day, also the directors, no, the
Yes,
director pending
yes.
the petitioner to withdraw this case.
Huh?
The director,
Huh.
it is pending the petitioner to withdraw this case. Also the district limited education officer.
Yes. Who's appearing for the respondent? Where is Mr. R. Muzumdar?
I'm only for respondent of 5 lots.
Where is Mr. R. Muzumdar? R. Muzumdar. Wait for some time.
Obliged.
7.
Yes. This has been complied with. The direction to consider representation which has been considered and he has been given the benefit of MSCPS. His name appears at number 5.
Have you seen it?
My
Heard? Mr. H. McGill. Willful disobedience of the directions contained in the order. David Swinto passed in W. Swinto. So in terms of the order, the following direction, by the said order, the following direction was issued, para 4. Since the directions were not complied with, petitioner export by filing the present writ petition. During the pendency of the writ petition, the order dated 19/5/2025 came to be passed, whereby the name of the petitioner along with other similarly situated employees have been considered for grant of financial upgradation. Stop. The petitioner, who is serving as entomologist cum research officer within bracket Filaria, who has completed 20 years as on 6/2/2016, has been granted one MSCPS benefit with effect from 1/1/2007. Since the directions contained has been duly complied with, this court not consider it necessary to proceed further in the contempt petition. Accordingly, contempt, taking into consideration the submissions made and in view of the order dated 19/5/2025 issued by the Commissioner and Secretary, Government of Assam Health and Family Welfare Department, the contempt petition stands closed. Notice is issued are written.
Laila.
May I please, Lordship? Lordship, can you take it for time being? My senior is in court tomorrow 1.
Time being.
Please.
Time.
May I plead the previous last order dated 7/4/2025. They were asked to obtain instruction.
Last financial year, all of FS was used on issued on 21 but last date of submission was expired on. So please take it as so we will process. Crazy instruction.
You had sent proposals.
In earlier year, previous year, it was financial sectional field, but submission of FOC was expired. And so therefore, they are taking steps.
Where is the direction of the court?
Page 14. Right? Paragraph 7. The operative.
When will it be granted?
They are taking it, 7 times.
They were supposed to take
7
steps
days.
within 90 days. As per the order. Have you seen the order of the court?
Yes, my lord, but it was expired on 8/3/2020.
No, have you seen the order of the court 5/2/2024 writ petition
my lord.
order? Do you have a copy of the contempt petition with you?
Yes.
Come to page number 14. Page number 14 of the contempt petition.
Yes.
Read para 7. So you are in contempt, you did not complete within 90 days, so you are in contempt.
Last sentence given,
So we'll issue contempt notice on your client. Who is the person responsible here?
not then number one, yes,
Respondent one.
yes.
Who is to comply with it? Who has given you their instructions?
Then one. Then one is the secretary, the head. Then respondent number three is the director. This secretary will provide it.
Why was it not complied within 90 days from the date of the order?
The government, because of that finance, that, was,
Have you filed your affidavit?
Yes.
Bring it on record. Whatever instructions you have, bring it on record. No, you file another one. Bring it on record or we are issuing contempt notice against the respondent.
will be able to do the update.
You are not doing the court a favor. You are under the direction of the court to comply. You must comply or go in appeal.
Yesterday I communicated verbally.
Oh,
Yes.
your verbal good
Yes.
wishes are all right. We
They
appreciate
say
that.
within 2 days they will process.
You bring it on record by affidavit by next week. Or we are issuing contempt notice. Proceeding in contempt. Do you understand that? Please convey to them. Today itself. Okay? List on 30. Petition respondents are permitted to bring their instructions on affidavit as to in support of their contention as to why the directions contained in the order dated so and so, passed in WPC so and so, was not complied with.
Massively.
Seconds 11 and 12.
May it please your lordship. My lord, advertisement was issued for the post of administrative officer in the deputy commissioner office at Bajali. The rule that is provided is, my lord, the ministerial rules of 1967 amendment in 2009, 681. The advertisement is at page 20, my lord, in the writ petition. Readings are complete, my lord. Advertisement at page 20.
Hmm.
Admittedly, my lord, I am 12 years senior to respondent number 4.
All right. Readings are exchanged. Who's for the respondent? Department.
CID has filed, but.
Where is JD?
Hearing today. They have filed affidavit also into.
You are the selected candidate.
And for respondent number.
Your appointment is under challenge for the post of
Administrative officer.
administrative officer. There are 4 private respondents,
My lord.
3 private respondents. You are appearing for all 3.
No, I am for respondent number 4 in both the races.
And who is for 5 and 6?
They have served, but they are retired, but
They are retired.
they are not appeared.
Office note dated 11 to 25 says, my lord, an affidavit in opposition by respondent number 3 has been received, flag A. Then on 10 to 25, service in respect of 456 has been completed. And on 16/5/25, an affidavit in opposition by respondent number 4 has been received,
All right.
flag B.
It is submitted that the pleadings are complete in the matter. Matter be listed for admission in the
Next.
month of June.
Next Friday, my lord.
Come for admission. June.
A date may be fixed.
6th of June.
No.
My lord, 6th of June, I have a difficult one.
You give us your calendar first, then we'll fix the date accordingly. You tell us what is convenient for you.
On 9th or 13th, lord. On 9th, Monday.
All right, 9th.
No, nothing.
9th
Yes,
June.
9th.
Wait, please, my lord. My lord, kindly fetch us a new justice. Earlier, the justice was misplaced, my lord.
Huh?
Kindly let us allow us a fresh justice then.
What happened? You have taken Dusty.
Yes, my lord.
You have taken Dusty service.
No, my lord. It was misplaced by the clerk, my lord.
You go and approach the registry. Why do you want an order? We have already given an order to take Dusty. Petitioner prays for another 3 weeks' time to take Dusty steps. Prayer allowed. Please recording. Yes.
In this case, my lord, your lordship, we have a penalty order of imposition of penalty, man. And your lordship has judgment and order that your lordship will find at annexure 4 page 72, man. That is 19/3/2005, my lord. That your lordship has come to a finding that the inquiry report, the word not, it was was found in my petition, was not found in the record. Ultimately, your lordship has come to a finding. That finding part I am coming to it, your lordship. The page 81. Paragraph 17.
Yeah.
In the absence of such materials, court must conclude an inquiry report was not duly served on the writ petition. Copy of the inquiry report served on the writ petition indicates inquiry officer concludes the petitioner is not guilty of the charges. Consequently, upon the petitioner served with a second so-called notice and question as was whether disciplinary authority could disagree with the finding of the inquiry officer, if so, whether the disagreement note should be served on the writ petition. At this point, this aspect need not be dealt with, as the learned government advocate has fairly submitted. The inquiry report available in record word not was struck out was likely not the copy served to the petitioner. If that is the case, it must be concluded that in accordance with the provisions of Rule 9A of the Assam Disciplinary Rules and relevant judgment of West Court, the petitioner was not served with a correct copy of the inquiry report. Consequently, petitioner was deprived of opportunities prescribed by law to ventilate his grievances. In light of the above, next paragraph, respondents are directed to serve a fresh copy of the inquiry report, as found in the records of the department on the writ petition. Once the copy is served, petitioner will provide with proper opportunities to represent the case before the court file statutory appeal. Now your lordship will see when it goes back to the inquiry report, then it come back to disciplinary court, not the appellate court.
No.
Your
To
lordship-
represent before the concerned authorities and also file a
No, your
statutory
lordship,
appeal.
when it goes back, your lordship is
Right, if you have trouble with this, we can correct it.
No, now then when the penalty has been set aside.
Huh?
It has, because it will come again, face man. They will again issue a forwarded a correct inquiry report and to file representative any. And disciplinary have to again apply his mind, man. So the order of penalty cannot suspend, man.
What is the penalty?
Penalty was regarding that was a stoppage of increment for 2 years, something like that. That you will also find that increment for 2 years, that pays 74, my lord. Last paragraph, last portion. Finally, while order dated 19/9/2012, disciplinary authority imposed the punishment of withholding the petitioner's increment for 2 years with cumulative. That was the fact.
We will.
So, disciplinary authority has to
No,
apply.
we need not set it aside. We will clarify it that.
No, otherwise the disciplinary authority how?
No. Your
Because
there, there is a proceeding which is initiated against you.
Yes.
We have found that the inquiry report available in the records perhaps was not served on you.
Yes.
Ordinarily, we should interfere.
then we have to start from the.
Ordinarily, we should interfere.
Yes.
But we are not interfering with the inquiry proceeding.
Not proceeding, but the order.
Therefore, it is, we can clarify it, directing the authorities will take a proper decision on the matter after serving you the.
Yes, that I understand. Then the punishment will go, my lord. If it has to, if the disciplinary authority has to decide the matter afresh, that penalty cannot remain, my lord. Because disciplinary authority,
Alright,
after,
we'll think about it then.
yeah, because
We
let it
will
be
issue
stuck.
notice at this stage then.
yes, let it, because the disciplinary authority has to make a call, man, afresh, right? In view
Heard.
of this fighting.
Mr. P. Pataki, Learned Counsel for Petitioner, MS
Kate Aludela.
A. Talukdar, appearing for the respondents, issue notice returnable 2 weeks. We may, it can be altered by saying that the copy will be served on you.
Yes.
And in the facts of the case, you may prefer a fresh appeal. Did you prefer any appeal?
No, we not be one because it has, since it will go back to the disciplinary authority. So disciplinary authority again has to decide after serving the correct copy. So from that stage it onwards it will go over. Come. So other things, my lord, the decision of the earlier decision has to be set aside by. That afresh he has to
We'll
apply.
think about it.
Yes.
It may
That will
not
take
be,
also-
because you see, the only reason why it was served on you was because there was some striking out.
I understand, my lord, but
But the effect of the order essentially remains the same,
yeah,
which was served on you. It is not a case that the inquiry of
yes, but correct copy was not served. That is the problem.
except for one word.
That is change the whole thing, my lord. Because he has not, they come to a finding that no.
We'll file affidavit.
No affidavit required. This is a review. We are only asking you get the record if required.
Yes.
Since Talukdar appears, notices are waived. However, extra copies will be
Extra
furnished
copies.
within the course of 1 week from the
Mark.
list after the return of the.
Have the copies of the case, my lord.
My lord, in the petition, my lord, they have used the word pump operator everywhere. My lord.
Hmm?
They have used the word pump operator in the petition. And now, my lord, they are seeking the amendment of the designation. Ideally, my lord, it should not make a difference because they essentially mean the same thing. But in the petition, in their own petition, they have used the word pump operator several times. So, my lord, will it be right to allow this amendment? My lord? That is
His actual designation is Khalashi, man.
What is the IA for?
I for the correction of the page number 9, my lord, in the lord will find after his name, the designation is pump operator is written. It is actually his
No,
work.
but that you have noted it in the writ petition itself.
Yes, but
Then you filed the case as a pump operator.
it was designation was written wrongly, my lord, as pump operator.
Wrongly, we had passed an order.
Yes. At the time of submission of this application order before the authority, they have
You are appointed as what?
Khalashi, man.
Khalasi. When did you file the writ petition?
Petition, my lord, in the year 2021, my lord.
21.
It was a mistake.
When
my
was it disposed of?
disposed of, my lord, 24, my lord.
Then for 3 years you did not know it was wrongly recorded.
We have filed the, my lord, miscase long back, my lord. It was registered.
What do you mean registered? You
Because-
you should have brought it before the court on the date when the matter was disposed of.
Uh,
What do you mean you had filed it before?
my lord, after getting the order, my lord, the party has come to know. Actually, it was a mistake on my part, and I was not aware.
No,
of
are
this.
you saying that you filed the IA during the pendency of the writ?
No. After the disposal, my lord. In the month of
What is the
August,
difference if the name is changed?
my lord, I know it should not make any difference, my lord, but I'm still, my lord, wondering why this I need to allow.
Mere wondering will not help. If you have an objection, you file your objection. Do you have any objection?
Right. We'll file an objection, my lord.
Don't file an objection for the sake of filing it. If you have an objection, say so. Is there any difference between a khalasi and a pump operator?
It's the same thing, my lord, that they work in the roles, master role. And the Khalasi can also work as a pump operator. It is more
You
or
get your instructions and bring it on record. Exact position, what what was he appointed and what was his role in the service. Third counsel for the parties, standing counsel for what is this? Water
PHE.
resource,
PHE, my lord.
irrigation.
PHE.
PH. Will obtain instructions in the matter. 6, liberty to obtain instructions in the matter. List again. Yes.
Lordship, I'm thus appearing for respondent number 6 on behalf of SK Mithili.
M. Das appears on behalf of accountant general. Yes.
Any date, my lord, up to it?
Let it be in the month of June, 20 June.
Obligation.
May I please, Lord? My Lord, I filed this application for correction of the, my Lord, name of the contempt nurse, my Lord. As per your Lordship's order, my Lord, we have taken state, Lordship, Lord, when we went to have the copy, my Lord, the spelling one alphabet is different, my Lord. That's why, my Lord, the contempt nurse didn't accept the notice, my Lord. That's why I filed this application for correction of, my Lord, name. That's on number 3 and 4, my Lord. Page 5, my Lord.
What is the name shown?
Name shown as Benjamin Rongmai, my Lord. It should be Benjamin and my Lord. Page 5. Can you see page 5, my Lord? Subudda.
What have you written in the contempt petition?
We have written, my Lord, Subud, S-U-B-O, only one alphabet, my Lord. Page 5, my Lord. Page 5, para 4. Can you see, my Lord? Page 5, para 4.
Third counsel for the parties. This IA has been filed seeking liberty to correct the names of respondent 3 and 4. Stop the respondent 3 and 4 was the names of respondent 3 and 4 in contempt petition number so and so was shown as Benjamin Rongma.
Wrongmai, my Lord.
Benjamin Rangma. R-A-N-G-M-A. Paragraph 4 underline for it. When his actual name is Benjamin Rongmai. Similarly, respondent 4's name was wrongly reflected as Supup Das. When his correct name is Subut Das. The application has been filed seeking liberty to correct the respective names of respondent 3 and 4 in contempt petition number 7. Accordingly, let the matter be accordingly as prayed for, and since there is no objection, the respondent, I extend the law. The petitioner is allowed to correct the names of respondent 3 and 4 by filing amended course title before the registry within 2 weeks from today. I accordingly stands allowed disposed of. In the contempt petition, you write, in view of the order passed in IA, view of the order passed today in IA number so and so, petitioner is permitted to file amended course title for correction of the names of respondent number 3 and 4. Is reporting.
Right.
Your Lordship. Okay, I filed this IA for striking out the name of respondent number 2 and add the name of Director Social Justice and Empowerment as well as Director of Women and Child Development and respondent number 4 and 5. Lordship.
Striking off of respondent 2
Respondent number 2.
and
And in place of that, Lordship, add Director of Social Justice and Empowerment, as well as Director of Women and Child Development, Assam Ujan Bazar is Respondent 4 and 5, as they are necessary party.
So if you strike out number 2,
Lordship.
your number 2 is, what is the, who is number 2?
Number 2, Lordship, Director of Social Welfare, Assam.
You want to strike it off.
Lordship.
And who's number 4?
4, Lordship, Director of Social Justice and Empowerment.
In your IA,
Lordship.
page number 3, who's
number
number
three,
three,
Lordship.
who's number 4?
Page number 5, Lordship, can you see?
Page number 3,
Lordship, page number 3, Lordship.
who is number 4?
Number 4 is Director Handloom and Textile.
Number 4,
In IA, Lordship.
yes, IA.
Handloom and Textile, Lordship. That's my number 4.
Handloom and textile, is he a necessary party or not?
Necessary party, Lordship.
Necessary party. So you'll have to, if you strike out number 2,
Lordship.
3 will become number 2.
Lordship. Lordship.
So you have to rearrange the respondents.
Lordship.
Any objection? Heard. Counsel for the party. The IA has been filed, praying for certain corrections in the course title, in the contempt petition, WPC numbers will show. In the writ petition, the following were earlier shown as respondents, page number 2 and 3, respondent 1, 2, 3, 4. So thereafter, now an IA has been filed, praying that the respondent number 2 is required to be struck off, and in place of that, respondents 3 and 4 and 5 are to be arrayed as party respondents. So in respondent number 2 is to be struck off, and in its place, Director Social Justice and Empowerment and Director Women and Child Development Assam are to be arrayed as respondents 4 and 5. Prayer made is not objected to by the respondent. Accordingly, I stand allowed. The Director Social Justice and Empowerment Assam and Director of Women and Child Development are permitted to be arrayed as respondents 4 and 5. So the respondents are accordingly rearranged. The respondents in the writ petition after the amendment will be number 1, State of Assam, number 2, Commissioner and Secretary Handloom and Textile, number 3, Director Handloom and Textile, and 4 and 5 at page number 5. Yeah. The petitioner will file amended course title within 2 weeks from today. I accordingly stand disposed of, allowed. In WPC, you write, in view of the order passed today in IA number 2. The respondents are rearranged as 1, 2, 3, 4, 5. Matter be listed after the petitioner files the amended post title within 2 weeks.
Deeply obliged.
This is filed for substitution of the name of legal heir of the writ petitioner. And writ petitioner died during pendency of the writ petition. And to this extent, we have filed the death certificate, that is page 7, annexure A.
When did the writ petitioner die?
Yeah, on 8th February 2025.
Not yet abated.
Not within time. They are the names of the legal heirs.
Who's for the respondent?
Okay,
Any objection?
No.
All right. I allowed. Heard so I stand allowed. I seek substitution of the legal heirs of late Dr. Pawan Varnakar, who was the petitioner in WPC number 20. the petitioner expired during the pendency of the writ petition on, when did he expire? 8/2/2025, leaving behind the legal heirs. So the application has been filed by the legal heirs seeking substitution of their name. Application has been filed by the legal heirs. Where is the legal heir certificate?
That is page 8, Lordship.
Dear daughters, Lordship, married daughters.
Married, all are married.
By so and so, so and so, so and so, huh? The applicants claim, applicants seek liberty of the court to be substituted in place of the late petitioner on the basis of the next of kin certificate dated so and so issued the petition. I said aloud, petitioner will file amended post title within 3 weeks from today. In the writ petition, you write, in view of the order passed in the IA 20, the legal heirs of late Dr. Pavan Swarnakar, namely 1, 2, 3, are substituted in its place. Amended post title to be filed within weeks, placed under the petitioner takes steps for filing amended post title before the date speak.
Hello.
Mr. D. Upamanyu for Health Department and
R.K. Talukdar for
R.K.
respondent.
Talukdar for respondent number, the Accountant General. Yeah.
Thank you.
Yes, if the Lordship, last occasion, I could not place the steps on that Lordship, private respondent is joined or not, Lordship, private respondent already joined.
What
Private-
is to be done today?
They have supposed to file application, rejoin the application. I have already filed application.
Lordship, my senior on leaks in another court, Lordship.
Ask for detail, Lordship.
The request made for the council for the petitioner. Matter stands passed over to be listed after 1 week. MS RB Bora for the
I am the
PTC.
number 8, my.
Huh?
Yeah, no, I am for the respondent number 8.
Mr. Tuenzo appears for respondent number 8. Yes. Yes.
My lord, my senior is on legs in port 5, my lord. I pray that maybe.
Yes.
My lord, order of this honorable court has already been complied with, my
Complied with.
my lord.
No, Lordship, not a complaint.
Huh?
Not a complaint.
Direction of this honorable court is page, my lord, 11, my lord.
There is specific direction, Lordship.
My lord, to regularize his period of suspension, my lord, that has already been regularized, my lord.
So in this case, they have already submitted and kindly have a look the order dated 3/12/2024 of this court, Lordship, in this position.
What is the direction of the court?
Direction of the court, Lordship, to regularize the service suspension period of the petitioner and payment to the unpaid subsidy allowance and the benefit of annual increment. Page 11. The direction to comply within 31/5/2023. Already 2 years gone, Lordship. They have not complied, Lordship. And the office of the director and the DO directed the petitioner to withdraw this case. Whereas they will not comply. They certainly let the petitioner, Lordship.
The direction was to dispose of the representative by speaking order.
Lordship, they have not passed any speaking order, Lordship.
My lord, speaking order has already passed on 30 July 2024, my lord.
Lordship, in this regard, can you have a look the order dated 3/12/2024 of this court?
You know, what are these? This is hardly legible. What is this that you want to place
Lordship,
before us?
that was already they produced on last occasion 3/12/2024. Honorable Court recorded their permission, Lordship.
3/12.
3/12. Their order, which has been placed by this my colleague. 3/12. Already in the record, Lordship.
My lord, kindly peruse communication dated 22/5/2025, my lord.
On perusal of the order dated 37/2024, it appears that no specific decision has been taken by the director as to how the period
What
of
exactly are you submitting? I am unable to follow, Government Counsel. What is it? What is this?
Sir, this is in regard to my lord, the petitioner
What is the direction given by the court first?
regularize the pension
Have you
period,
seen the order?
my lord.
Have you seen the order of the court?
My lord.
Please read out the specific portion.
My lord, last para, my lord, in the event of filing such representation by the petitioner within the time,
So in the event of filing, so some representation was permitted to be filed.
my lord, they have filed, my lord.
Right. So the direction is to dispose of the representation
My lord,
by speaking order.
my lord.
or not before.
Where is that order?
I have just submitted, but that is not eligible, my lord.
You get a legible copy.
My lord, after some time.
Lordship, that order already in the record, Lordship. It is keep in record as a X, Lordship. In the order dated 3/12, it is reflected. A copy of the order dated 7/2024 produced by so and so counsel for respondent shall be keep on record and marked as X. Same order they have produced each and every occasion, Lordship.
It's not here. X is something else.
37/2024.
Huh?
37/2024, they produced the order on 3/12.
We have seen the order, but it is not marked here as X.
It's complete violation of the court order, Lordship. They have not complied with it.
Where is the order? Give us a legible copy. Give us a legible copy. After some time.
For admission, I think
This case, Lordship, in 2011, my lord, the petitioner was appointed as a member of Home Guards, Lordship. He was, my lord, sent for training, Lordship, and successfully completed, my lord, training at page 11, kindly, see, Lordship.
Yes.
Page 11. My lord, this is a, my lord, certificate, my lord, saying that he has successfully completed the training and was appointed as, my lord, member of Home Guard, Lordship. He will be called on duty, my lord. Now, in 2011, he was sent for, my lord, he completed, my lord, training, Lordship, and appointed. But he was not, my lord, called on duty, my lord. In 2019, my lord, only 15 days, my lord, duty was provided to him, Lordship. Since then, my lord, he has not been called on, my lord. Other, my lord, Home Guards, my lord, they have been, some Home Guards, my lord, have been routine manner, my lord, have been called on duty, Lordship. But the petitioner has not been provided any duty, my lord. The petitioner has submitted application. That is not, my lord, considered, Lordship. As per section 6(3), Lordship, my lord, Home Guards can be appointed, my lord. He may
6(3) of what?
Of Home Guards Act, Lordship.
Where is that? Where is 6(3)?
6(3)(a), Lordship. Appointment of Home Guards, Lordship. 6(3)(a), my lord, here it is, my lord, subsection 1. Home Guards Act, Lordship. Local Act, Lordship, volume. I'm making.
You get a copy and give it properly before us, not like this. You take a copy or you give a cheat, they will take out a copy for you. Home Guard Act. Law. Huh.
22. We have an instruction lordship, but this is of 2022 lordship. We need to updated instruction lordship.
What I am submitting lordship on my lord, maybe directed to consider lordship.
Whatever you are submitting, we'll have to look into the papers. It is not here.
Lordship.
So you give a cheat that this is the act that you want, court master will take it out, we'll examine it. How am I supposed to know what act or judgment you are relying on unless you share? And if you don't share, what is the point of you carrying all the books and cases if you don't want to place it before the court? Maintain a system.
Yes.
You want the court to look into it, doesn't mean you are going to thrust it under our face and say, yeah, I've got this copy, have a look. You have that, give a list properly, whatever acts, rules you want, give it to that item number so and so, these are the books necessary. Right, look, you can take it out. We'll call it up in 2 p.m. Second half.
Yes.
Yes.
Let
All right.
21.
Which is, each time may be granted lordship to file our affidavit.
Affidavit has been filed, my lord.
Three weeks time. Mr. K.R. Patgiri appears for the petitioner, M.S.R. Devi, and CTC prays for further 3 weeks time to complete her instructions. Prayer made is allowed. List after 3 weeks.
All right.
May it please your lordship, I respectfully request that the matter be passed over for the day.
On the request made on behalf of the counsel for the petitioner, matter stands passed over.
lordship, we have not
Listed
received
after 1 week.
we have not received extra copies.
After 1 week, renew your prayer.
My pleasure. In this case, lordship, the respondent number 6 and 8, lordship, and submit the affidavit in opposition, lordship, and I have to file reply, lordship. So 2 weeks time is required.
Counsel for the petitioner prays for 2 weeks time to file a reply affidavit to the affidavit by the respondent. List after 2 weeks.
Obliged, lordship. Obliged.
Getting on behalf of the respondent. Okay. Some time to file our affidavit.
Mr.
M. Gogoi.
M. Gogoi appears on behalf of the respondent. Pray for how much time?
3 weeks.
3 weeks time. He's looking at you. Either you say yes or 2 weeks. 2 weeks. 2 weeks time to file affidavit.
Oh, let's do it.
List after 2 weeks.
My lord, in this case, regarding the selection appointment post for the Gao Pradhan, my lord. And today, my lord, respondent to file
Have you filed affidavit?
Today file. And my lord, the record is required, my lord, from the deputy commissioner, my lord.
You want to file any reply?
No, my lord. Today they file. I have not gone through.
All right, then let us first have this order. The
My lord,
affidavit.
main thing is, my lord,
Mr. H. Ali appears for the petition.
Commissioner is the
Mr. S.
main, my
Dotto, Sounding Council appears for the Revenue Department to submit that an affidavit is filed on behalf of the Revenue Department today. Stop the copy, however, the affidavit stated to have been filed, however, is not on record. Matter be listed after in the next week.
Next week, my lord.
Registry will ensure the registry will trace out the affidavit stated to have been filed with the
Well,
respondent.
other respondent not,
case
that
report.
may be reported. Other respondent did not file any affidavit, that may be, if
They have
required.
not filed, we'll decide.
Yes.
Yes.
Item 28, Lordship, with item number 28, 30, 31, 32, and 33, I received the instruction in filing my affidavit, sir. And in item 29, Lordship, they have to make DG BSF and DG Assam Rifle as a party because the document verification was done from their work. They have not made them a party, sir. In item number 20,
Item 29, Lordship, few days, 1 week may kindly allow, I have to submit an IA, Lordship, for impleadment.
for DG BSF and DG Assam Rifle. And rest of the matter, Lordship.
Roy, please submit that in item number
28, 30, 31, 32, and 33, I have received the instruction.
28, 29,
29, they have to implement.
28, 30,
31, 32, 33.
31, 30, 33. It petition number by item get of but not down the instructions are complete. We like to make them. There are new Mr.
AR Karim.
AR
Karim.
Karim, hearing in item number
29.
29. Submits that you'd like to file an IA for implement.
One more Lordship, for petitioner number 6, where the document was done was not mentioned in the petition.
Petitioner 6 in which matter?
In item number 22, where he wants to file IA.
That you first. That you first complete it. That you first complete the implement. How much time do you require?
3 weeks, Lord.
3 weeks.
Ultimate takes a day, Lord, after 3 weeks, if it is not in.
Roy, please complete it time to file the
After 3 weeks, any day, Lord.
It's after 3 weeks.
Date may be Lord, after 3 weeks. Because the selection and already appointment given, Lord. Although we have Lord Chief qualified.
2020, 20.
20 of June. Deep Lord.
Item 5.
Passed over.
Yes, Lordship.
All right. Item 35 next week. At the request made on behalf of Council Pradhan.
Kindly pass over for some time being.
Still on legs.
Okay, my lord, import one.
Respondents, any respondents here? Who's for the respondents here? CGC? Mr. Gupta had appeared last time. Where is Mr. Gupta? We'll grant further time to the respondents to file their affidavit. MS so-and-so appears on behalf of Mr. R. Mazumdar. Although the respondents were granted liberty to file their counters, the same has not yet been filed. Further 2 weeks time granted to the respondents to file their affidavit. Please start 2 weeks.
Okay.
Well, this matter pertains to the employee of the Hotel Brahmaputra also. And only dispute is when the 30 years of lease was terminated, the hotel was demolished and employees were given one severance package, which was under the 2016 ROP. Thereafter, my lord, 6 pay commission, sorry. And thereafter, 7 pay commission came into effect after this act was done with effect from earlier date. So first, I am claiming, my lord, whichever period I have been working for this period, I want that salary under the 7th pay commission, and remaining severance package should be considered under the 7th pay commission. Hence, my lord, on the date of 31st of April 2023, my lord, the order may be perused. 21st April 2023, one order was passed
by the
Honor-
court.
Yes. 21st of
21st
April
yes.
23.
Yeah.
And my lord, the government advocate was directed to take the instruction since when the other employees who are still working got the benefit of this, my lord, 7th pay commission. Thereafter, my lord, one affidavit in reply has been filed by the ATDC, Assam State Tourism Department, but that part, my lord, since when it was applicable, that part they clearly did not state, my lord. Thereafter, my lord, another affidavit has been filed by the government advocate, filed by the secretary, commissioner and secretary. Then also that part was avoided, my lord. Hence, my lord, on 6th of September 2014, sorry, 20th of February 2025, another direction was given to the government advocate to take that instruction. However, my lord, I have the 7th pay commission with me, which clearly states that it is retrospective during the tenure of my service. So if everybody is getting that benefit, why we should not have that benefit, my lord?
Yes, respondent.
That only part, my lord. There are other claims also.
Lordship, regarding that specific order, Lordship, we have sent letter, Lordship, but that instruction is still awaited. Lordship, we will seek instruction, Lordship. At this time.
Which department? Tourism. Who is to give you the instruction?
Listen,
Tourism department.
respondent number.
Tourism department.
Yeah.
Respondent 3, not 4.
3, Lordship. What is the managing director, Lordship?
4 is the corporation. The ROP, applicability of ROP will be,
3, Lordship.
the information will be available with 3.
3, my lord. And all the packages has been, and the financial benefit has been
Get a
given.
positive, get a specific instruction on the, how much time you require?
10 days time, Lordship.
10 days time. This court had earlier directed by order dated 21/4/2023 had earlier issued directions, had earlier directed the Tourism Development Corporation to apprise the court by the next date as to when the Assam services within bracket ROP routes 2017 was made applicable to the Tourism Development Corporation by the state government. There are several other orders have been passed by the court pursuant to that, and opportunities were granted, but this information is not forthcoming at this point. Today also when the matter is called up, government council prays for further time. There are purely for the end of justice, we permit the government council to complete her instruction. She prays for 10 days time. Matter be listed immediately after 10 days, by which time the respondents 3 and 4, namely Commissioner and Secretary, Government of Assam Tourism Department, Dispute, and the Managing Director, Assam Tourism Development Corporation, will apprise the court, will furnish instruction, will apprise the court as to the date of applicability of the Assam services in bracket revision of pay rules 2017 in respect of other institutions under the tourism department. So it is made clear that if the instructions are not forthcoming, consequential orders may be passed by the court.
Right.
Is recording.
Time.
Yes.
Well, in this case, I prefer a little time, my lord.
Sorry?
It can be taken up next week, my lord, on 29th, my lord. Today I have some difficulties, my lord.
29?
29th, my lord.
29.
Subject to your lordship, I convenient, my lord.
Can it be on 30?
30, I have the other matter, my lord.
29 because it is a hearing day, so pleadings are complete here.
All pleadings are complete, my lord. But at 20, it can be on 28th, my lord.
28.
Well.
At the request made by the learned the accountant, Mr. N.C. appearing for the writ petitioner, assisted by MS Nuetto, matters that paper to be listed on 28th of May. MS Bora appears for
On behalf of Mr. F.T. for all the
for all the respondents. 28th.
Item 40. Lordship, here I don't find my affidavit. Lordship, let it be fixed for hearing, Lordship.
Hmm?
In any other day, Lordship, probably Lordship, law point involved in this case.
What is the issue?
Issue, Lordship, here is this, that this petitioner was put under suspension, Lordship. Thereafter, there was a departmental proceeding against him, and in departmental proceeding, nothing could be found. So suspension was revoked. Then there was a speaking order, Lordship, where in the speaking order, 2 increment has been deducted. The allegation against him was that he has tried to forge the signature of the chief minister. That was the basic allegation against him. But that allegation could not be proved. So we are now challenging that if my suspension order has been revoked, the 2 increment should be dropped. The 2 increment that is being curtailed from me, that should be dropped. That is the main contention, Lordship.
No, what about the departmental proceeding?
That has been dropped, Lordship. Nothing could be found here. Dropped.
That, where is the order of increment? Stoppage of increment?
Stoppage of increment, Lordship will find. Speaking order, Lordship will find in the annexure number 8.
Page number?
Page number 34 of my 40 of my amended petition, Lordship. And stoppage of increment, Lordship will find in annexure number 3, Lordship. That is period of inflicting punishment of curtailment of 2 increments. Annexure number 3, page number 31. Inflicting punishment of curtailment of 2 increments, nullifying promotion scope in future as per the provision of discipline and appeal so and so. And the case of so and so is finally disposed of. That was the. It is decided to drop the suspension order via order number so and so against Dilip Kalita, grade 4 office peon with penalties. Inflicting punishment of curtailment of 2 increments and nullifying the promotion scope in future as per the provision of discipline and appeal rule 1964, and the case of so and so is finally disposed of. That is the order under challenge, Lordship. Page 31. Annexure 3.
What was the order passed in this?
In the speaking order, Lordship?
Yes, speaking order for what? What is the, why?
Speaking order, there says that punishment
No, why was the speaking order passed?
Speaking order was passed, Lordship, because I have approached this honorable court by filing a writ petition. And then in the writ petition, it was found that this matter will be considered and a speaking order will be passed. So accordingly, a speaking order has been passed.
Where is the order of the writ court?
Writ court order, Lordship, will find page 39, Lordship. This aspect may be considered by disciplinary authority, appointing authority, for which the petitioner may submit a detailed representation within a period of 2 weeks from today, and the authority shall consider and dispose of the representation by passing a speaking order within 1 month from the date of the receipt of the representation of the petitioner. So accordingly, I submitted a representation, Lordship, and my representation has been disposed of by speaking order dated 19/8/2019.
All
That
right.
is,
Now, if you come to the speaking order,
yes, Lord.
page number 41,
Lordship,
third paragraph from
Lordship.
the bottom.
Yes, I got it, Lordship.
Read that.
The order, punishment order still stand was confirmed by the Chief Engineer Irrigation. That is it. But there is nothing as such.
No.
And in their
It appears that the curtailment were imposed as a distinct punishment.
as
I
a
ordered it
punishment,
at 12.5.
as a punishment, but my
Where is 12.5 ordered?
12.5. 12.5 is Lordship will find in page number 31, annexure number 3. Okay,
31.
yes, Lordship. Now, Lordship will kindly see it is decided to drop the suspension order. My submission is, if it is decided to drop the suspension order, then further infliction of punishment is perhaps not found in law. And in their affidavit that they have submitted before this honorable court, Lordship, in their affidavit they have left it upon this honorable court to take a decision.
Yeah.
Lordship, in the original writ petition, Lordship, I filed an affidavit annexing the sealing order, Lordship, passed by the chief engineer, Lordship. It is page, Lordship will find it page 40, Lordship.
Like speaking order is there, we have also
40
annexed.
40 of the Lordship,
Writ petition.
no, Lordship, affidavit in opposition filed by the respondent 2. Have left it to the honorable court, Lordship.
They are saying that it depends upon the honorable court now. They have written in paragraph number 3 of their affidavit, Lordship, that as regard the curtailment of 2 increment. Yes, oh, check.
Where is the earlier order 9/5/2016 passed in WPC 1256?
That is, Lordship will find. I have the order dated 12/4/2019 order. I have, Lordship.
If you come to page number 40, which is a speaking order enclosed to the affidavit.
Yes, yes.
Second paragraph, you will
Yes,
find there is
Lordship.
a reference of a High Court
1256/2016, Lordship.
page. Where is that order?
That order I am not having, Lordship. I will try to, I will have to find it out, that order. Then. That is this 9/5/2016 order. I think,
So there was no proceeding initiated.
It was initiated, it was dropped. Thing was initiated, it was dropped.
You get that order? When can you get it?
Lordship, this 9/5/2016 order, Lordship.
Monday?
Monday, I'm at some personal difficulty, Lordship. Can Lordship allow me 1 week time, Lordship?
Why 1 week? Just download the order and
Yes, I will download this order. Then let it be on Wednesday or Thursday next. Lordship.
Wednesday, 28.
28, Lordship. 26 to 28, I am on leave, Lordship.
30.
30, all right, 30.
Matter be listed on 30 again. On which date? The council for the parties will endeavor to place the order dated 9/5/2016 passed in WPC 156 of 2016 don't we take it out ourselves instead of troubling you? Order to let you come back at 2 p.m. Let us see.
Lordship,
Oh.
okay, my friend want to do it on some other day, Lordship.
Let us have a look at this order.
Lordship, deeply obliged.
The order. Like my order. 2 p.m.
2 p.m.
Alright.
Yeah, please, Your Lordship. Here in this case, my lord, meetings are already completed, my lord, and it's related to correction of date of birth, my lord, of the petitioner. At the time of declaration of their service, my lord, the date of birth was incorrectly recorded, my lord. That's why the department have communicated.
You are
with-
retired now.
My lord,
You are superannuated.
so already superannuated, my lord.
So now how can a date of birth be corrected?
My lord, since my lord, they have incorrectly their date of birth recorded, page 35, your lordship.
When did you come to know? When did you come to know about the incorrect recording of your date of birth?
My lord, in fact, my lord, in the year 2000, after coming to know about this, my lord, they have approached before the honorable court in earlier writ petition, but due to some typographical mistake, my lord, same writ petition is withdrawn, my lord. I have also annexed this writ petition, my lord. At page 62, my lord. They have approached before this honorable court in the year 2019, my lord. And
62.
page 62, my lord. WPC number 4160/2019, my lord. And department have initiated the process in the year 2008, my lord. After regulation, that is at page 35, my lord. Petitioner's name appears it as page 37, my lord, type copy, my lord.
When it is already reflected here, what else do you want to say?
My lord.
Vernacular copy of the service book, that information is not there.
But subsequently, we have corrected this, my lord. And
How have you corrected it? How can you correct it?
because, my lord, in fact, it's a typographical, my lord. And from your lordship, may have found the affidavit of the department, my lord. They have stated all this, my lord, para 5 and 6, my lord.
Readings complete? Yes. It's for hearing. Right.
Date may be hit, my lord. These people are poor employee, my lord, and they are not receiving any salary, my lord. They are hoping that their case.
Why are they not receiving salary?
My lord, since they have already superannuated, my lord, that's why they are not receiving salary.
How will they receive salary?
That's why, my lord, your lordship may early date if your lordship pick.
Early date
In the month of June, my lord.
after reopening. July It will be in the month of July after you.
Obliged.
Let it be month of July immediately after you.
After summer vacation.
Yes.
If your lordship fixed it.
So far away, why should we fix it? Make a massive difference.
My lord.
For
PWD.
report 34.
Finance.
Right.
My lord.
Yes. Your period has been regularized.
Lordship, but the
The incremental, some increment have been stopped. Withheld.
So that instruction already produced by the Honorable Court on 3/12/2024. Kindly have a look at this order. 3/12.
3/12.
3/12/2024. Appraisal of the order dated 37/2024, it appears that no specific decision has been taken by the director as to how the period of suspension should be treated. In other words, on regulation of the period with effect on so whether the petitioner should be given benefit of the full salary required to be clarified. They have not clarified it till that.
In terms of the direction of the court, your claim for regularization of the period of suspension and subsistence allowance was to be paid. That was your grievance before the court.
Okay.
Court said file representation, dispose it of. Now they have regularized your period. There is no information as to whether subsistence allowance has been released.
Okay, that is that.
But the two incremental benefits have been withheld.
Lordship, already that is my case also. The Lordship, can you have a look the order, Lordship? Two increment already stopped at the time of suspension. Lordship.
I am looking into the order. Please read the order.
The last line of in the event of the filing of such representation, the petitioner within the time so specified, the Director of Limited Education Assam, on verification of the relevant record, shall dispose of the same by a speaking order on or before 31st May 2023, after given an opportunity of hearing to the petitioner. for regulation of his period of suspension.
So you challenge this order if you're not happy. You are entitled to challenge this order. Some order has been passed.
No, Lordship, they have not give the suspension allowance, Lordship. That also order also there, Lordship. For the period of 4-6
Subsistence
years,
allowance, what has happened to the subsistence allowance?
they have not, that is the direction, Lordship.
The direction of the honorable court is to my lord dispose of his representation, my lord. That has already been
No, representation after giving an opportunity.
Sir, that has already been given, my lord.
Why don't you read the order, that part of the order, last paragraph?
Part, Lordship.
Read the last paragraph of the order.
My lord, instruction dated, my lord, 20.
No, we are not interested in your instruction. You peruse the order of the court. Page number 11 of the petition. Last paragraph.
My lord, there is excess dual of salary, my lord. That is my lord.
Do you have a copy of this order?
My lord, I have already given, my lord.
Do you have a copy of the court's order?
My lord, I have, my lord.
Read that order.
No, in the event of filing such representation by the petitioner within the time so specified, the Director of Elementary Education Assam on verification of the relevant records shall dispose of the same by speaking order on or before 31/5/2023 after giving an opportunity of hearing to the petitioner for regulation of his period of suspension, payment of unpaid substantial allowances and the benefit of annual increment as per his entitlement in accordance with law.
Now, here that suspension thing is not here.
Okay.
Everything else is there, but the suspension thing is not here. Whether you have, he may not have been reflected, like you may have given him the subsistence allowance.
So, Lordship, the honorable court on 312 record this, their submission.
Well, after T12, my lord, I have given my lord 22/5/2025. The communication dated or letter.
This is something to do with arrear salary.
My lord.
Okay. Subsistence allowance is different.
My lord.
Where is that?
My lord, may take it next week. My lord, I will take instruction my lord, regarding substantial allowance.
The petitioner has been taken in by the director to withdraw this case.
That is not my knowledge.
His salary will be stopped.
You bring it on record.
I'll file a affidavit.
You bring it on record. If there is a threat, you bring it on record. The instructions permitted to be placed before the court is not complete. So far as the responses are respondent's elementary education is concerned. Let the matter be listed next week.
Really fix it.
See.
Obliged.
The government advocate is permitted to bring complete instructions.
Obliged.
Sir, put it up for private your court.
Question number 5, Lordship. We have complied with our part.
But the matter pertains to promotion. If Lordship would go back to the order of 27th of August, 2024, my lord, when the matter was argued, my lord, the provision of new set of rules in 2019 had come in, and they are of a different ministry. So whether these rules are also made applicable to the Ministry of Home Affairs.
27th of August.
My lord.
Yes.
2024.
Yes, instruction.
That specific instruction is awaited, Lordship. One instruction is received but not clarified that whether the 2019 rules are applicable in the recruitment process or not. That
Where are the rules? Are these rules on record?
19 rules are not on records. They have stated in the affidavit that we are also abiding by them. But then we have put a question that these are of a different ministry. So whether the Ministry of Home Affairs has adopted it or not is the question, my lord, that was raised.
If the pleadings are complete, then
Otherwise complete.
we'll proceed for hearing. List the matter in the month of, this is a promotion matter.
My lord.
July. Let the matter
Yes.
be listed in the
Then in the
third week
meantime,
of
this
July.
could be placed, my lord. Otherwise, if this instruction
They
is
don't
not
place,
placed.
we proceed on the pleadings available. If the affidavits have been filed, pleadings
lord.
are complete, why should we wait for instruction? They have any specific instructions? It's not applicable because their affidavit says it is applicable.
My lord.
Then, so what further instruction is required?
My lord, because the rules are of a different ministry.
You
So whether
challenge it.
MHA has adopted
You
it.
make your arguments on that. Their affidavit is on record to say it covers. You say it doesn't cover. It requires a decision of the court.
Definitely.
List on in the third week of July for hearing, as it is stated that the pleadings are complete.
Obliged.
Kindly, it the last week of July.
Why?
I am not available.
Last week.
Second week is holiday.
No, I said third week.
Third week.
You are not available on the third week. After reopening,
After immediately not.
you are extending your holiday. Right, let it be in the last week of July. Last week of July.
Obliged.
May it please your lordship, my lord, here the petitioner and the respondent number 7 were appointed in a Pani Jogan Asuni in Ghagrapara, and the petitioner belongs to the landowner family. They were appointed during the pendency of the writ petition. The petitioner got married, and now she has been stopped to be paid the honorarium.
Because she was
And
married.
my lord.
Because she was married.
Married, and maybe she has left the place. The notification that is issued in pursuance to it is from their document, orders of the governor, as regards the following was incorporated in the notification for supply of drinking water. I found one clause where it says he or she should be resident of the command area of scheme. So, my lord, the respondent number 2 and 3 has not filed any affidavit till date. 2 and 3. The mission director Jal Jivan and the executive engineer PHE. He has to clarify this position. That is very necessary.
The issue is that this Jal Mitras, they are engaged by the water user committee, Your Lordship, and the honorarium
water
user committee. The water user committee is a committee. The PHE just makes the plan and hands it over to a particular area. Thereby, a water user committee is formed by the local people. Thereafter, they collect fees from every household who's getting the benefit of the water pump, and they give the honorarium to the Jal Mitra, Lordship.
No, who makes the appointment?
The water user committee, not the PHE. The water user committee makes the appointment.
In pursuance to the rules of under the PH.
What does the rule say?
Rules is that, my lord, affidavit filed by the respondent number 7. That is that
Starting from page 73.
page, it starts at page 63. Affidavit filed by respondent number 7. Whatever my friend is suggesting, my lord, those should be brought into record by way of affidavit. Annexure 6, page 63. 63.
Respondent number
7's affidavit, it starts at page 63. Orders of the Governor of Assam Amendment for the water schemes for operators and volunteers giving the Jalo Pani Yojana. Page 64 is the relevant. Eligibility of scheme operator volunteers.
Respondent 7.
My lord, respondent number 7.
There is no respondent 7 if not it is there. Yes.
Page 64.
60.
It starts at page 63, relevant at page 64, eligibility of the scheme operators volunteers.
Yes.
My lord, the second E stroke C should be resident of command area of the scheme. Now this has to be clarified by the department. What is the command area of the scheme? Maybe because of my marriage that I have gone.
This is by
PNRD.
PNRD.
PNRD is a clear file lot of this one.
It is by the respondent number 7 who have annexed that. And their allegation is this: after marriage, I have been 20 kilometers away from the scheme area.
What is the command area?
Command area, that is, my lord, because I am staying at, my lord, during my petition, when I was a writ petitioner, I was in Nalbari, Ghagrapara, Nalbari.
Who is to clarify that?
PNRD has to clear because it's a notification to PNRD a lot.
PNRD has to clarify.
Who is for PNRD? Are they a party here?
You have to, the phone number 7 is the phone number.
video is a party a lot.
BDO will not represent PNRD.
Yes. PNRD.
PNRD is not a party.
Not massive, made a party.
PHC is the party.
PHC is a party.
Only PHA is a party. PNRD is not a party.
But if you want a clarification of this, it has to be by PNRD.
Yes.
Because the notification is by the PNRD. But we will have to file an application for impleading.
Mr. P.K. Roy Chaudhary, Learned Counsel, admits that clarification of the PNRD department be required in respect of the orders dated 22nd of July 2024, which lays down the eligibility of the scheme operators / volunteers. Stop. One of the ground specified therein shows that the person should be a resident of the command area of the scheme. So, the petitioner was earlier a resident of Ghagrapara, Nalbari, and pursuant to her marriage, she has moved to her matrimonial home in
My lord,
20
kilometers away in the area.
kilometers away. And thereafter, although she was serving as a scheme operator for under the what is that scheme?
Chili Pani Jogan Achoni. Chilling Pani Jogan Achoni.
CH.
CHILLING.
Chilling Pani Jogan Achoni within quotes. And which the petitioner claimed and which the petitioner claimed the orders dated 22nd of July 2022 specifying the various guidelines or rules, including the eligibility criteria of the scheme operators in respect of such scheme, will govern the conditions of employment of the scheme operators like the stop. A perusal of the order dated 22nd July 2022 reflects that the orders are passed by the Panchayat and Rural Development Department. So, although the PTO, Origog, Bonbok, Block, Nolbari, is arrayed as Respondent 5, the Panchayat and Rural Development Department is not arrayed as a party respondent. So, the Roy Chaudhary submits that you'd like to take necessary steps for impleadment of the Panchayat and Rural Development. It raised for 2 weeks' time. 2 weeks or 3
No,
weeks?
2 weeks.
Weeks. Mr. R.R. Gogoi appears for PHE, Mr. J. Kolita for
6 and 7.
Respondent 6 and 7. Matter be listed after 2 weeks.
Okay.
That's great.
This case, Your Lordship, I prayed for 2 issues, Your Lordship, for non-payment of arrear salaries and the stagnation in promotion of the repetitioner. Readings are almost completed, Your Lordship.
Almost.
Already, yes, completed, Your Lordship. Thing is that the petitioner has been promoted for
You are praying for pending salary.
pending salary, and the other issue is the for promotion. Since he has been deprived for the next promotion after completing almost 28 years in a post of LDA. Then in 2023, she has been promoted to EDA. So the service rule has specifically mentioned that upon promotion should be considered on merit cum seniority basis. But in this case of promoting me, the merit has been considered, and I have been promoted to the LDA. So I have been the other similarly situated person has been promoted, who is below to me, has been promoted to the higher post, Your Honor. One of the which is arbitrary, and for that I have filed this petition, Your Lordship. And
You have two prayers. Two prayers.
Two prayers.
Or one prayer.
Two prayers.
Two prayers. One is arrear salary.
Arrear salary.
In the post in which you are working.
Yes, sir.
And the other is promotion from the next to the next higher post.
Yes, sir.
Those are two different issues.
Two different issues, Your Lordship. But the thing is that one issue has been almost as per their instruction, they are going to repay the paying the amount. That has to be resolved within a short period. The second issue is that the promotional aspect is very much not clear by the department concerned. She is in stagnation in service for last more than 27 years. That is the one of the contention of my writ petition, Your Lordship.
Yes, arrear salary
Arrear salaries have been already paid. May I submit
to the petitioner.
Yes, sir.
Right.
The total entitlement is rupees 4,77,894, which have been paid by sanction order dated 21/2/2025 and 24/1/2025.
No, but the amount shown is 1,20,000.
Your Lordship, the next document, it shows 3,57,404. The total amount is 4,77,000.
You have received the amount.
I have to take instruction there.
What instruction? It has already been directed to be credited to your account.
Now it is May, in the month of January and February.
I have to take instruction, Your Lordship.
I'll give.
I have to take instruction on this aspect, Your Lordship.
Heard Mr. H. Borwal, an accountant for the petitioner, and M.S. G. Swami appearing for the respondent.
Assam Plain Tribes Development
Assam
Corporation.
Plain
Respondent
Tribes
number 4.
Development Corporation Limited. And you are also appearing?
1 and 3.
MS.
On behalf of Ardhar. And the
Respondents 1 and 3 on behalf of
Ardhar.
Ardhar. The petitioner is before the court with two different prayers. The first is for the a direction to release the arrear salary to the amount of rupees so and so amount. Stop. And the second is a further direction to the petition to the respondents to consider a claim for promotion to the next higher post. Stop. Pleadings have been exchanged in the matter. Whereas today, when the matter is called up, the learned standing counsel, Plain Stripe Corporation, has placed before the court communication dated 24/1/2025. Two communications, namely 24/1/2025 and 21/2/2025. These communications reveal that the payment found to be due to the petitioner towards her arrear claim has been released to her bank account. Stop. By communication dated 24/1/2024, amount of rupees 1,20,490 was released in favor of the petitioner in the bank account bearing number so and so, serial number 12 type. And by this communication dated 21/2/2025, amount of rupees 3,57,404 was released to the petitioner in her bank account number so and so. Stop. Counsel for the petitioner, however, submits that he is not posted with such instructions and craves leave of the court to complete his instructions. Stop. Be it as it may, since there are two prayers in the writ petition and one having been stated to have been resolved by the respondents, matter be listed for hearing in the month of August.
August, Lordship, in the July, in the month,
August,
last,
in the month of August, as the pleadings are complete.
last.
10:46.
This case, my lord, respondent number 6, affidavit opposition, I also filed reply, my lord.
Right.
Incomplete, my lord.
Lordship, it takes it for hearing.
Hearing, my lord.
What is the issue?
My lord, dismissal from service, my lord. But
It is
I did
submitted
not-
that pleadings are complete in the matter. The petitioner challenged the proceedings also.
Also, my lord.
You have challenging the proceedings also.
Proceeding also, my lord, inquiry.
Disciplinary proceedings and the orders of dismissal passed by the disciplinary authority. It is submitted that since the pleadings are completed, matter be listed for hearing. MS
Respondent 7 and 8, Ms. Somila.
is so and so appears for respondent number 7 and 8.
Yes.
And for 1 to 6 and 9.
MS M. Bhattacharya for respondent 6 and 9. Private respondents have also filed. Who are the private respondents?
My lord, it is that, my lord.
Inquiry officer and presenting officer.
Prepared, Lord.
Inquiry officer, my lord.
Inquiry officer. By name, party has been made.
Why? Inquiry officer.
And deputy inspector of police,
No,
my lord.
why have you arrayed them as parties? Inquiry officer
Inquiry officer, my lord.
and presenting officer.
Inquiry officer, my lord.
All right. Matter be listed in the month of August for hearing. The respondents, state respondents will keep the records connected to the proceedings ready for perusal of the court if the need so arises. List according.
Right.
47.
Quickly obliged, Lordship.
In this case also, my lord, I also filed reply, my lord.
Reply.
Reply.
Arbitration matter.
Arbitration, my lord.
Appointment.
Appointment or arbitrator.
You are objecting.
My lord.
Huh?
My lord.
You are objecting.
My lord.
Why?
Well, I've explained my affidavit, my lord, to the region.
All right.
Yes.
He wants to file reply. It is submitted by Mr. P.R. Patil.
Already filed, my lord, reply.
You have filed it.
Filed, my lord.
Oh, okay.
It's for admission hearing, my lord.
What admission? All right. It is submitted that the pleadings are complete in the matter. It requires.
Like fix a date, my lord, 23 matter, 24 matter. On hearing day, my lord.
List on 3rd of June
My lord.
for admission.
So can it be any other day, other than 30? After 3rd.
Then,
Hello.
my lord.
10th of June.
Obliged.
Okay.
Your Lordship.
Yes.
In terms of the last order, Your Lordship, I think there is a communication dated 16/5 office note where they have,
Lordship, can you peruse the last entry in the note?
I think arbitrator has given his consent. 16/5.
So we appointed third counsel for the parties by the earlier order dated 3/004/2025. Sri Sushil Kumar Sharma, retired district and second judge, was appointed as the prospective arbitrator, subject to furnishing of a written declaration under section 12(5) of the Arbitration and Conciliation Act 1996. So, the pursuant to communication of this order, the learned prospective arbitrator has furnished the written declaration dated 16th of May 2025, whereby he whereby it is informed that there is no impediment on his part in acting as an arbitrator in the said matter. Stop. Accordingly, having perused the written declaration, issued written declaration dated 16th of May 2025, and the on perusal of the submission, perusal of the pleadings available on record, and consideration of the submission made, Sri Sushil Kumar Sharma, retired district and session judge, is appointed as arbitrator, sole arbitrator, to decide on the disputes and differences that is the reason pursuant to the contract between the parties in respect of contract agreement number so and so order to 34 order. The parties will appear before the arbitrator on June. 6th June?
Yes, sir.
6th of June?
Lot.
6th of June, along with the and place this copy of the certified copy of this order. Registry is also directed to communicate a copy of this order to the arbitrator appointed by this court. The arbitrator will thereafter proceed. Will commence his proceedings as per law. This court.
Okay.
Lordship, it was Mari Ulay.
May I please go on?
Yeah.
Today there is difficulty now, but moreover, they have filed their affidavit in reply day before yesterday. That is also not in the record.
Not on record.
It on 21st, for some reason, it's not on record. Anything next week, if it's
Next
not
week.
inconvenience.
It is submitted by the at the bar that affidavit in reply. You have
Yes.
filed a reply.
Yes, affidavit.
Affidavit in reply has been filed by the petitioner. The same, however, is not available yet for registry to trace out the affidavit in reply stated to be filed with the petitioner connected to the case report. As agreed to by the parties, it's this matter again on failure. You want it next date, next week,
Next week, my lord, if it's not inconvenience.
4th?
4th.
Of next.
4th of June.
4th of, extremely good.
Yes.
Please, Your Lordship. Lordship, native part institute due to not appointing the petitioner for the post of Gram Pradhan, Your Lordship. Your Lordship, this petitioner has already been selected, Your Lordship. For the
File appeal. Appeal.
No, it was not, there is no alternative remedy because I am not against the selection, Your Lordship.
Then
They have been selected. And my grievance is that I have not been appointed for the post, Your Lordship, since long. It was, I have been,
you have not been given the chart.
no. It was not, so there is no provision for appeal in that regard, Your Lordship, with due respect, Your Lordship.
Yes.
Lordship, we have filed your affidavit.
Yes, they have filed their affidavit.
What have you stated?
They have stated this
Page
one.
number, Lordship 3, Lordship. Point number
Public
7.
complaint.
There is a public complaint, Your Lordship, from the secretary and president of one ATSA organization, Your Lordship, on 3
The
grounds.
pass order is on that.
Your Lordship, on 3 grounds, they have raised their objection, Your Lordship.
They have not filed a reply, Lordship.
No. Your averments at para 7
Lordship.
states that some inquiry is made, conducted by circle officer, and he has submitted the report. Now, who is to take an order, take a decision? Somebody has to take.
Deputy Commissioner.
You take a decision.
Lordship.
That much we can direct.
But with due respect, if Your Lordship kindly permits me to submit on that ground, Your Lordship, because the affidavit is in my hand.
Then you'll have to challenge this. It's not on the challenge. You have come to know about the inquiry report pursuant to the affidavit file.
Lordship. Even before Your Lordship, we got to know about the complaint, Your Lordship.
But have you challenged it?
Yes, we have filed our objection, Your Lordship, before the circle officer, Your Lordship. We have filed our objection.
No, the report which the circle officer has
Lordship.
given, that is not under challenge.
It is not on the challenge, Your Lordship, but
So as on date, the authority before whom the report, before which authorities is submitted?
it was, they have submitted ADC, Your Lordship, response number 3.
ADC.
ADC, Your Lordship. Revenue.
ADC, has the ADC passed any order? No order.
No,
So we can direct them to pass an order. Consider it.
Lordship. That is that much.
Yes.
Lordship.
Heard. Counsel for the party, this petition is filed with the petitioner, who claims that he was selected as a Gram Pradhan for the village Sekoni, Borhula, post office and PS Dohola Bundan. Stop. The petitioner had applied in pursuance to the advertisement bearing number NRK 31/2022/52 dated 5/9/2022 for the post of Gram Pradhan. Stop. Pursuant to the said advertisement and the selection conducted, petitioner was selected. So, in the copy of the in the selection list, which is enclosed, which is available in the website, web portal, petitioner's name appears at serial number 13.
13.
Showing the name of Moza Chatial comma, number and name of the lot / the village is 14 Sekoni Borhula. And the name of the candidate, namely the writ petition. Stop. Although select list was published on 11/3/2023, no appointment orders have been issued by the authorities concerned permitting the petitioner assume office of the Gram Pradhan of the so-and-so village. Stop. Consequently, the petitioner appeared before the court. Did you file any representation? Did you file a representation?
Representation you have filed, your lordship. before the
Which is that?
service.
Page number?
Page number, your lordship. 32, your lordship, the Varnicular.
32.
Lordship.
Petitioner also furnished, also filed the.
Lots of representation, your lordship.
Huh?
Lots of representation. 36 also, your lordship.
No, 32 is filed by whom?
By some villages, your lordship.
Not by you.
Not my.
How is that relevant? Did you file any?
I filed one objection, the reply of that complaint, your lordship, at page number 39, your lordship. Type of, your lordship.
Anyway, you write, while the matter was thus situated, petitioner came to be informed that some local residents had filed an objection before the circle officer against the appointment of Salim Ali.
No, it was in support, your lordship.
Hmm?
It was
No.
for the appointment, your
Somebody filed an objection.
lordship. Lordship.
Objection against the so-and-so. Stop, pursuant to which the petitioner was informed and he also submitted his representation / objection before the authority, before the circle officer. Stop. Thereafter, the circle officer concluded the inquiry and submitted it before the ADC Nagaon. ADC Nagaon.
No problem, lordship.
Stop. However, no orders have yet been passed by the ADC or the DC Nagaon. And the petitioner, although was the selected candidate, no order of appointment has yet been issued. Being agreed, the present writ petition has been filed. The respondents dispute the contentions raised and have filed their affidavit in opposition. Stop. The affidavit in opposition encloses an inquiry report passed by the circle officer, Puliapur Revenue Circle. Stop. From a perusal of the said inquiry report, it is seen that some complaints were raised by some persons belonging to the T community, T tribe community. And various allegations were made against the writ petition. Stop. The circle officer has submitted a report after the inquiry. Stop. there is no dispute that pursuant to the inquiry report furnished, no specific orders have yet been issued by the respondent authorities. So it is also not in dispute that the petitioner applied for, appeared for the selection process undertaken for appointment of Gram Pradhan and was shortlisted and was selected as the Gaon Pradhan for the so-and-so village. So under such circumstances, at this stage, without expressing anything on merit, the writ petition stands disposed of with the direction to the Deputy Commissioner, Nagaon, to look into the grievances of the writ petitioner and take necessary steps for passing appropriate orders for appointment of the writ petitioner. If in the event no other order, if in the event no other person has been appointed in the said post of Gam Pradhan in the meantime. So any if the petitioner is found eligible, if the petitioner, if the appointment, if the selection and appointment of the petitioner is not found to be as per provision of law, then before any steps are taken, the petitioner should be put to notice and given an opportunity of writ petition accordingly disposed of in terms of the above. Let the order be carried out within a period of 30 days, 60 days,
30 days.
30
already-
days from the date of receipt of a certified copy of. It's good. And 51.
Well, the matter relating to proportionate pension matter. Kindly have a look at page 30, matter. The affidavit filed by the respondent.
Yes.
This affidavit has been filed, matter, in the month of April 2024, matter. Now, more than 1 year, matter. Page 30, matter. Paragraph 7.
30.
30. That is the affidavit filed by the respondent. Matter, from the middle portion, matter.
Yes. Yes.
The office of the Superintendent of Police so-and-so, Assam Deputy so-and-so, petitioner to report the office of respondent of element to submit relevant documents for process of family pension. Subsequently, petitioner has reported to the office of the Superintendent of Police and process for her family pension has already been initiated. There is a stand value taken by the respondent in the month of April 2024, madam. Till 2024, till today, madam, 2025, May, madam, they have not taken any step. They have admitted, madam.
Yes. Any instructions further?
As per our last instruction, Lordship, that information is still awaited, Lordship. This instruction is of
More
repeated,
than,
Lordship.
more than 1 year, madam.
We close the matter directing them to consider and pass whatever orders are there for release the pension within 60 days from the date of receipt of the certified copy of this order. There is an affidavit, you go through the affidavit, you have admitted
Lordship.
that he is entitled. Anyone for Accountant General? Any instruction?
Yes, Lordship, family pension paper has not been forwarded to this office.
Not forwarded.
Yes, as per 17/5/24 instruction.
How many years of service have you undertaken?
My lord, 8 years, my lord. More than 8 years. 8 years, 8 months, 21 days. Remaining, my lord, more than 10 years. He, on the date of my lord, date, my lord, his age was 50 years.
No, on the date you expired,
My lord.
how many years of service
8 years, 8 months, 21 days.
you had completed? What is the requirement under the rules?
10 years. Basically, my lord, this is 10 years, but 7 years is entitled for
Which rule, which provision?
Is my lord.
Pension.
Oh. Base, my lord, 500 pension rules, my lord. Page 573, madam, in the pension rules, madam. 573 page number. I have not today, madam, the pension. Page number is 573.
You know the page number, but you don't have the book.
I have.
Yeah.
Section 142, madam. That is 7 years. Render service more than 7 years. Then he is eligible.
This is what disappear in 142. 140.
But page 21 is the first office member number.
No, you have to get your instructions here. Why the papers have not been sent? The Accountant General has the instructions that you have not sent it because it is less than 10 years. Get it by next week, 30. 30. Matter be listed again on 30, on which date the respondent Department of Home
Home and political action.
Home and Political will prize report as to the status of the steps taken to process the papers for pension, family pension, proportionate family pension to the request. Is on 30.
Diploma.
You one day take it back. On video, man.
May I think, Lordship?
Yeah.
Lordship, kindly pass over the day, pass over the matter for the day, Lordship.
Pass over.
For the day, Lordship.
Why?
Lordship, my senior mistake and is in outline bench, Lordship.
Yes, some others in the matter. I have been ousted from my job.
Next week?
Not that week.
Next week?
That element.
30. Let it be on 30. At the request made on behalf of the respondent, matter still be listed again on 30. Please be noted.
Outline.
My lord.
Yes.
My lord, I was promoted to the rank of Assistant Conservator of Forest and thereafter to Deputy Conservator of Forest. But it was a retrospective effect was given accordingly by creating supernumerary posts. Now, notifications were issued at page 34 and 38 in the year 23, giving financial benefits with all approvals. Those having not been given to me, I retired, my lord, now, I filed a writ petition. Because the financial benefits which were to be granted to me for the retrospective promotions were not granted, although approvals were there. During the pendency of the writ petition, an affidavit has been filed by the AG. If Lordship takes up that affidavit at page 1450, the annexure,
Yes.
it's a communication by the Senior Accounts Officer dated 16th of January 25 to the Secretary of the Environment and Forest Department. The last is that requests to clarify the issues.
What are the issues?
Issues are, number one, Shri Binod Paing in his aforementioned writ petition has stated that upon being appointed to the rank of SEF under Rule 4C of the Assam Forest Service so-and-so rules, has successfully passed half-yearly departmental examination conducted by the APSC in the month of November 22 to fulfill the criteria as prescribed in Rule 8A for confirmation in service under Rule 9. However, Government Order for Confirmation and Rule 4C in respect of Vinod Kumar Paing, retired DCF, in original does not appear to have been received in the office till date. This is number one. And number two, consequent upon promotion to the rank of ACF and DCF by government so-and-so, a supernumerary post in both the cadres were created to accommodate Shri Vinod Kumar Paing by government order so-and-so for the period this and this. However, the treatment of the betwixt period, 4-10-11 to so-and-so, is not clear in this office. I know this is the only thing which was left to be done. And this was in January, they had requested the department. Today we're in May.
Yes, department.
We'll issue a press communication because we have not received any instruction. So my God, 3 weeks may be granted. I'll take.
If Lordship kindly takes the pages 34 and 38, that's my case, 34 and 38.
Yes.
Page 34.
34.
Of the writ petition. May I read?
What?
Oh.
Yes.
Page 34. This is by Additional Secretary, Government of Assam, Environment and Forest Department. The Governor of Assam is pleased to relax the provisions of FR 17.1 by invoking FR 5A to allow financial benefits to Sri Vinod Kumar Paing, AFS, on account of his promotion to the Assistant Conservator of Forest with respective effect for the period 29 August 2009, the date of taking over charge for the promotional post by his junior Sri Kamleswar Thakuria in the promoted post, to 18/8/20. That is date of taking over charge. This is approval. My lord, financial benefits granted by the Additional Secretary, Government of Assam, Environment and Forest Department with the approval of the Finance Department. And this clarification now the AG is seeking from the department, which 4 months, 5 months have gone by. They're not taking that. Yes, we have granted much earlier. Number one. So this meets 34 and 38 would meet the first query. Now the mid-fixed period, Milord, what happens in the period, the intervening period? Now this they have to clarify. Because once you promote me by creating the supernumerary post, grant me the promotions retrospectively, the benefits are granted, even the finance approval is there. There is no way that any hindrance or anything against me. Only thing is that paperwork need to be done first. Let them do that. A direction will affect me, nothing more.
I don't I'll pursue this matter. 2 weeks maybe.
Let us find out what instructions come
My lord.
instead of disposing it of today.
Very good.
Because
Today, my lord,
we can only dispose it of today with a direction that these information be
it
furnished.
should not be. May I pray today is 22nd, 23rd.
Yes.
Can it be sometime in the next week, my lord? He can get the instructions at least.
You can have it on. You'll have it on 6th of June.
Could it be on 5th of June, my lord?
Why? What is wrong with 6th?
6.
You are not available.
No, I mean, I will be available, but in the midst of an arbitration matter, it may take the entire thing.
No, they say that available. Then we'll have it on the next 9th, maybe.
9. May I pray for the matter being treated as part of the matter? Lordship has heard the matter, in fact.
What part heard? We only require the instructions, that's all.
Lordship
We'll keep it on
indicates
9th.
9.
Keep it on 9th. Let's see what happens. Heard till for the parties. It's still on 9th, enabling the Standing Council Forest to complete instructions in respect of the communication dated so and so. Issued by
16th of January.
16 January 2025, issued by the Accountant General's Office.
Senior accountant.
Stop. Mr. Bhattacharya appears for the Accountant General.
Apply.
Based on 9th.
9.
Yes.
My case is Lordship against the dismissal order. What has happened before Lordship? I was appointed as Gambura. Thereafter, based on the allegation of a stranger Lordship, I was placed under suspension. Meanwhile, Lordship, against that suspension order, I prepared an application before this Honorable Court. During the pendency of that application, Lordship, they have closed my inquiry and then finally dismissed me. And now 2 stands have been taken in the while suspending me and while in the dismissal order, Lordship.
The pleadings are complete. Affidavit filed.
Affidavit filed, Lordship. Lordship, but it's been showing in the cause list that affidavit, but I have not served with that.
Huh?
I have not received any.
You have not
copy.
received.
Yes, I have not received any. Without serving, it cannot be filed.
Give her an extra copy. Furnish her an extra copy. Counsel for the petitioner submits that the affidavit filed by the respondent has not been received by her. MSA Talukdar, then a government advocate, submits that she will furnish an extra copy of the affidavit within a week's time to the petitioner. Mr. J. Handick appears for Revenue Department. Yes.
So kindly wait. Sir, my senior is on the way.
He's on the way.
Okay.
We proceed for drawing up contempt proceedings since no affidavit has been filed.
My lord.
Where is the order or where is the order?
Page 13, my lord. 11 for truth. Paragraph 10, my lord.
Yeah. Then it was rejected.
Not rejected, my lord.
Then?
No order has been passed.
Not placed. Yes, Mr. Nath.
Well, on behalf of respondent number 6, we have filed an affidavit, my lord. There, my lord, we have said in paragraph number 5, my lord, that in compliance with the honorable court order, my lord, the proposal was submitted by the political department to the finance department twice, my lord. But the finance department with an endorsement that page number 19, last page, my lord, last para. However, the finance EC2 department informed by the endorsement dated 5/4/2024 that no new proposal regarding granting of minimum of the pay scale will be considered by the finance department for implementation of the honorable court order dated 8/6/2017 passed in table number so and so, and to that effect, the finance department has provided their letter that is 16/9/2021. That letter we have annexed Annex 1. So here the respondent number 3 is also there, my lord. In the contempt petition, the principal secretary of the finance department is a party here. And my lord, on 3/3
In the writ petition.
in the contempt petition,
Were they not parties in the writ petition?
they were party. They were party.
So who's for the finance here?
Finance not no name has been shown, but kindly take up the order dated 3/3/2025. On that day, while 3rd of March 25, passed in this contempt petition.
I'll report to that.
Court has in fact requested Mr. R. Borpujari, standing counsel, the department. He was present in the court on that day. But no wakatnama has been filed. None has.
I'll report to that. Standing counsel finance. So you will just take it up in a while.
Lot.
Let us see. Notices were served.
No, the name has been shown. Mr. Robi Kota, he is no longer possibly in the principal. Is the principal secretary of finance, because now he is the chief secretary of PASAP.
Who's respondent? What is the finance department?
Finance department is respondent number 3 in the contempt petition. Respondent number 3. They said Mr. Sri Robi Kota, principal secretary to the government of Assam finance department.
Our service is complete. Service is not complete. Respondent 3. Have you taken steps?
Steps were taken, ma'am.
5 and 6.
Radhika 5, my lord, is no longer in the office. For 6, I am appearing. 6 is only 6 is presently the commission.
Only for 5 and 6.
Yes.
You have not taken steps for 3. There's no marking here.
Hmm? 5 and 6, my lord, newly implemented respondents, my lord. Newly implemented. earlier respondents fellows we took steps earlier.
Steps have been taken, but there is no endorsement that respondent 3 has been served. Only 5 and 6 have been shown.
That is after including the new respondents fellows.
They have been served. Specifically on respondent 3, there is no office note. Mr. I. Sokia, counsel to the petitioner, Mr. P. Nar, learned counsel appearing for respondent number 5.
Six.
The Nath submits that an affidavit has been filed, including the Finance Department communication dated 16 September 2021, whereby all departments were informed that where is that no new?
Kindly come to 7. This list will be treated as final list approved by the finance department. Henceforth, no new page 22, serial number 7, annexure 1. This list will be treated as final list approved by the finance department. Henceforth, no new proposal submitted by any administrative department for grant of minimum pay scale to the master role work charge schedule and similarly placed workers who were appointed prior to FRPM period. Prior to period in person to the Honorable Court order dated 8786/2017 in WA number 45 of 14.
All right.
Will be considered.
Got it. By this communication, finance department intimated the government, the various departmental commissioners and secretaries that new proposals submitted by any department after this communication grant of minimum pay scale to master role, work charge, casual, and other workers who were appointed prior to AFRPM period will not be considered. Stop. Notice in the matter was issued as per Beckett 13/3/2024. Office note reflects steps have been taken on all the respondents. However, there is no endorsement whether steps on respondent number 3, namely the so and so, who was the principal secretary of the finance department at the relevant point in time, was shown to have been served. Finance department notice is not served. Are you accepting notice or
that principal secretary, perhaps Ravi Kota is not there. Now
are you appearing or we direct the office to give an endorsement that as regards the services being complete?
I will have to take it.
Then we'll record your name in respect of respondent 3.
My name may be shown in the cause list, my lord.
Respondent
Today,
3.
I skip the matter.
No. The cause list, it should be there. But don't expect each and every matter, each and every council's name should be there. We'll give a date, you note down in your calendar. Because there is a space constraint in the cause list.
I take it, my
but wherever possible, it shall be reflected.
my lord.
Mr. R. Borpudari, learned counsel, has who is standing counsel for finance department, being available in the court. The court has requested Mr. Borpudari to obtain the required instruction with the matter. Let the matter be listed again after 3 weeks. The instructions sought for from Mr. Mr. Borpudari will give instructions to the effect as to. All right, we leave it at that. What we want to say is that when there is no cutoff in the division bench order, whether the finance department can impose the cutoff.
Yes, sir. Per se, my lord, we are also of the view, my lord, that is not my lord.
So we are not putting it in so
Right.
many words. You
Right.
get your instructions, but to that effect.
My lord, I'll be seeking a copy of the contempt petition from my colleague. my lord. I will have to transmit that because that incumbent is no longer holding the post. Now, my lord, one commissioner secretary is there.
Further, Mr. Corpusari, from his information, submits that Respondent 3 is no longer the principal secretary, Government of Assam Finance Department. If that be so, petitioner is permitted to take necessary steps to implead the present incumbent, if so advised. Present incumbent of the Finance Department. Please take it or after 3 weeks. Names of all councils, including Mr. Porpusari and Mr. Dinar, be reflected in the post list by the registrar.
Oh, black.
You will serve a copy. You want it to put us in the record, in the order?
I'll serve.
You'll serve. Home Guard.
Section 6 lordship. Home Guard section lordship 1947 was amended in 2015 lordship, but section 6 has not been amended. My lord, appointment of Home Guard lordship. Married lordship.
Yeah.
Subject to the provisions of this act and to the rules made thereunder, any person willing to serve as a Home Guard and possessing such qualification as may be prescribed may be appointed as Home Guards. Now, subsection, my lord, 3, my lord. Every officer and every man of Home Guard shall receive on his appointment a certificate in form annexed to this act under the seal in the case of man, by virtue of which person holding such certificate shall be vested with the powers and privileges of Home Guards. My lord, as per section 6 lordship, he was appointed, my lord, he was, my lord, sent for training, my lord, he has been successfully, he had successfully completed the training lordship. The purpose of, my lord, training, appointment and training lordship, to, my lord, deploy any, in any place, my lord, where is required lordship. As per requirement, they are, my lord, called on duty lordship. But in 2011, my lord, he was, my lord, he had completed, my lord, training lordship successfully lordship. A certificate was also issued, my lord, and appointment. He was appointed as a member of the Home Guards lordship. My lord, in 2019, just 15 days, my lord, deployment was there, my lord, in election duty. Thereafter, also, my lord, no deployment. Never he was called for, my lord, duty lordship. He also submitted representation lordship. That is, my lord, at first 12 lordship. Even then, my lord, his representation was not considered, he was not called on duty lordship. My lord.
Yes.
Lordship, as I already have submitted, Lordship, that respond number 4 instruction we have received, but it is 2022, Lordship.
What does it say?
It says, Lordship, that no command has been received against the petitioner from office of the District Commandant Home Guard Manipur, Tejpur, to engage him in this office, Lordship. But this is not updated, Lordship. This is up to 2022. The matters have come after 2022 on the only, Lordship.
My lord, what I am submitting lordship. Now, my lord, the commandant, my lord, of Home Guards may be directed to, my lord, consider his application to, my lord, deployment lordship. If he recommend his dear lordship, then he may be deployed. Otherwise, all other Home Guards have been, my lord, deployed. Some have been routine manner have been deployed lordship. But the petitioner is not called on duty. It is arbitrary lordship. Then what was the purpose to send me, my lord, in training lordship? I am the member of the Home Guards my lord.
Where is your representation?
Representation is at his lordship 12 lord.
Where is the endorsement that it was received?
My lord, endorsement is not their lordship. If necessary, I will file, my lord, submit another application that may be directed be considered.
You file.
My lord,
which
it was
copy?
submitted, lord.
No, it was submitted, but there is no endorsement that it was.
My lord,
filed. It
endorsement
doesn't
is
even-
not there, lord.
It doesn't even have a date. Doesn't even have a date.
Well, it was submitted as per instruction, lord.
Yeah, maybe, but you should have asked him that where are the date, on which date was it submitted?
Date is, my lord, it is
Then
not
there is
written.
no endorsement that how it was submitted, who
No.
received it.
Date is not there, lord. What I have stated in the petition.
You file a representation. Why
Yes.
do you want an order from the court? You can file it on your own.
That may be directed to be, my lord, consider, my lord.
You have not even filed it. Where is the question of issuing a direction to consider?
My lord,
You have to
it
first
was
file
as
it.
per, my lord, instruction, my lord. It is by mistake, my lord, probably
Then
that
you
was
get-
not given, lord.
No, then you get information as to when it was filed.
Yes.
You have to get some information. The paper doesn't reflect anything. No date, no endorsement. Signature is also not very legible.
My lord, in this, in paragraph 5, my lord, it is stated, but on 8/9/2022, it was submitted, lord.
You obtain instructions whether on 8/9/21 it was submitted or not.
Lordship.
Matter be deferred to be listed after 2 weeks, enabling at the request of counsel for the respondent to obtain instructions as to the status of the representation dated 8/9/2020, stated to have been filed by the petition before the commandant, district commandant, with a prayer to engage him in an APP as trained guards. Learned counsel will apprise the court on the same by the next 8 weeks, on the next 8 weeks. List after 2 weeks.
Keep your
After 2 weeks,
That may be big, lordship.
6th of June.
How like?
6th of June.
How like?
In fact, in regard to his promotion, now everything will be clear if your lordship take up paragraph number 5, lordship, of my writ petition, page number 11. Paragraph number 5 makes everything very clear. Page 11, lordship.
Yes.
May I read it, lordship?
You are reading which order?
No, lordship was lordship at the pre-launch period. Lordship says regarding the order of 5/9/2016. Now this 5/9/2016, lordship will kindly see this is in respect of his promotion. Sorry, 9/5/2016. And paragraph number 5 make it very clear that after the order of 9/5/2016, lordship, he was promoted to junior assistant grade 3. And he was of the opinion that since he was promoted to junior assistant grade 3, then his punishment for the curtailment has been dropped. But that remains. That was never dropped. That is the main contention, Lord, for which this present writ petition has been filed.
May I submit, Lordship? I have to examine the case, Lordship, as there is no arise comment or anything that I want to examine the case, Lordship.
It is there, paragraph number 5 is.
Lordship may fix the matter in the next week.
I think, Lordship, there is nothing more to examine because paragraph number 5 is very clear. And in their affidavit, Lordship.
What is your prayer?
My prayer is to
The curtailment of the two increments.
to drop the curtailment of the increment. To increment. That is only my limited prayer, Lord.
There were two punishment, Lordship. The one has been, Lordship, he is promoted.
Get your instructions.
Lordship.
Chapter 6.
Lordship. Lordship.
Deeply obliged. Let him get the instruction so far as paragraph number 5 is concerned.
Not
Lordship, may I please your lordship? I have received instruction, lordship. I'd like to file affidavit.
Huh?
I have received instruction.
You want to file affidavit?
But that stage may not even come now. We have filed an IA and a writ petition.
Lordship, I have also received instruction, Lordship.
Very
Here,
well.
our instruction.
What is the IA about?
My lord, I am the second wife. My colleagues on the other side would represent the mother, and the father-in-law would represent the first wife. So initially there was a thing that how the pension amount or whatever retail benefits would be assorted. Eventually, in the writ proceeding,
First wife is alive.
no, we, not as per law, as per there were judicial proceedings here, and then we all consented how to get the pension amount or the retail benefits adjusted amongst us. There is no dispute, it's admitted position. 50% to me, 50% to the first wife, and we give 10% each to the mother. So 40, 40, 10, 20.
Your what late husband and son was employed where?
He was an unarmed branch constable, my lord. He died.
Government of Assam.
He died.
The pension supply.
Rules apply with all things in the judicial proceeding. We both, the first wife and the second wife, agreed that we will apportion it. Not by the rules, but then the Honorable Court allowed it. Thereafter, the mother intervened and said, I also have to be taken care of. And then in the judicial proceeding, it was agreed upon 40% to first wife, 40% to second wife, and 20% to mother, 10-10 from both. Now, while this arrangement was there, Lordship finds the arrangement at page 36. The order starts at page 32, operative is page 36. This is admitted position, not even disputed at all.
36.
36 of the writ petition, you know.
Yes.
May I read? Page 35, the last line will be relevant, you know. Since all the parties have agreed to the above arrangement and considering the facts and circumstances of the case, the two writ petitions are being disposed of as follows. 1. The mother of the deceased employee, Damian Bibi, will be entitled to receive 10% of the share of family pension receivable by each of the two widows of deceased Tayyab Ali, subject to revision of pension from time to time. Respondent numbers 5 and 6 in so-and-so to submit a joint application before respondent number 3 by enclosing a certified copy of this order with a request to pay 10% of the family pension to the mother of the deceased. The petitioner in 4015 will furnish necessary bank particulars so-and-so. So, amongst us, there is no difficulty that the first wife gets 40%, second wife gets 40%, and the mother gets 20%, 10% each from both the wives. Now, what the authorities had done, Milord, they had issued an order to communication page 37 and 40. I would not read it, Milord. It's there, 37 and 40. 39, whereby the first wife was being given the benefits. I assailed it in the writ petition. This is not the way it's done. I am to get 40% of it. You are to get 40%, and the mother is to get 20%, 10-10 from us. The Honorable Court was pleased to pass an order, Milord. That order in the writ petition was passed on 27 January. The order.
Page number?
But it's an order in the writ petition, Milord. And this writ petition. 196.
Dated?
27th of January, Milord.
Yes.
25. The interim part, the operative part, if I may read that part only. Having regard to the overall facts and circumstances of the case and the earlier orders passed by this Honorable Court on the subject, that the respondents are permitted to release up to a maximum of 40% of the total amount in favor of respondent number 11. That's the first wife, if so advised. So we are not even against the first wife. He would get the 40%. So what has happened is that due to pendency of the writ petition, Milord, our shares, the mother's share and the second wife share are being stalled, number one. And the IA we have filed, second wife has filed, the writ petitioner, that from December 24 till May, the pension share has also been stopped.
No, first tell us in terms of the earlier order,
Earlier order,
what was the penultimate direction here?
my lordships.
What was the direction in the matter?
Direction was that we get 50-50,
No,
first and second.
read it. Read the direction.
The mother of the deceased employee, Tamyan Bibi, will be entitled to receive a 10% share of family
So
pension.
this is the arrangement.
Arrangement.
What is
Receiving-
the direction?
The dispute intersect between the parties regarding sharing of family pension would stand resolved permanently. In view of the above arrangement, the impugn order dated so-and-so, passing so-and-so, whereby the entire amount of pension has been granted in favor of the first wife, Murshida stands interfered herewith. Earlier, the pension was entire given to the first wife. We filed the writ, the mother intervened, and this direction was given that we share. It was agreed upon by the parties. Thereafter, again, the authorities issued the impugned communications by which the pensionary benefits will be granted entirely to the first wife. This is where we filed this writ petition. Now, what happens is that
Now, pursuant to this order, what happened? The pension was granted in favor of the first wife.
my lord, no, everyone got. This order was
In terms of this order.
This order?
50-50.
this common order was 14,623. From 14,623, everything was smooth. Everyone was getting the share. Now, by the impugned orders in the writ petition, that is 25th of November 24.
Page number?
Page 37 is the first one. The second one at 39.
Yes.
I am to forward herewith FPP so and number in favor of Murshida Begum, wife of so and so and so and so, for amount such, my lord PM, are being enhanced and normally family pension respectively, and to request that the pensioner's portion of the order may be made over to him, her, after obtaining his or her signature on the disburser's portion, and after you have satisfied yourself on his or her identity and payments noted on both the portions as are made. The slip bearing the attested specific signatures left hand impression along with the photograph is enclosed herewith. If the pensioner wishes to draw his or her pension to an authorized agent, the pensioner's portion.
Who is Murshida?
First wife. We say after the High Court's order, 1 year everything goes correctly. Suddenly this comes up on November 24.
Who has issued this letter?
This was issued, my lord,
Accounts officer.
by the accounts officer, senior accounts officer. We challenge this and the order at communication at page 40. Both say goes to first wife.
What is the gist of this?
At page 37, my lord.
Yes, what is
It identifies Murshida as the one to whom the amount would be payable. We say this arrangement which suddenly crops up is not as per the judgment passed by this honorable court, where a consent order was passed. Everyone was happy with that. But once we challenge it, we protect the share of Murshida also. This honorable court says that 40% receivable by Murshida would be given to her. In fact, we jeopardize our shares. Those are not released. But now, the pension amount has also been stalled from December. No pension. To the extent I have left my residence with my two sons and gone to my brother's place. From Nagaon, I've moved to
PPO remains with whom?
My lord, it would be with the authorities in good
country. It is in three parts.
My lord.
There will be one part of the pensioner.
My lord.
So with whom? With the wife? Which of the wife?
Perhaps
the first wife.
It comes to page 36. Page 36 for a moment.
No, I am referring to the
Correct. Absolutely, my lord.
Page 36 is the arrangement.
Page 36 is the arrangement what to go. We were also understanding this, that by this arrangement of November, what would happen is that you identify a bank account and therefore it goes to both. Like a nominee. Nomination is done. Now from December, they've stopped the pension and this, nothing is coming to us. If Lordship clarifies.
The problem is self-created. The reason being that pension rules,
my lord,
have a very specific requirement.
143, your lordship.
That pension is to be paid to so and so, so and so, so and so. That's all. There is no concept of second wife, third wife, and all this. Only one person.
One PPO maybe.
Wife.
Correct.
So therefore, the PPO portion of that will remain with the person who is the nominee.
When this started in November, we did not come to the court. We came in January
whatever it may be.
when the amount was
That's
not
what
coming.
That is what the rules say.
Correct.
So these arrangements that you are making, you are entitled to make
We,
yourself.
of course, we made amongst ourselves with the seal of the Honorable Court also. But now, November, when the order was passed, we also made the same
Pension
understanding.
has to be released to only the person who is holding that PPO.
My lord,
The three names are not there in the PPO. Cannot be.
Cannot be.
page 36, the last paragraph.
No.
Both the writ petition stand disposed of by giving that the family pension receivable
That is
on
why
account
I
of
say
so-and-so
that is why I say
50-50.
your problem is self-created.
We came in January, my lord. They held back the pension amount, not only the benefits, even the pension amount. It was continuing from that period, 23.
See, this is an order you have invited from the court in your petition.
My lord.
This is contrary to the position and rules. For some reason or the other, I
My
don't
lord.
know how it has happened.
My lord.
It has happened. Otherwise, there is no difficulty. You may make an agreement amongst yourself.
That was done earlier.
It is recorded.
Recorded.
But the money has to come to only one person.
My lordships.
How can it be given towards the rules?
Even if that stand be taken, we, first of all, the disbursal amount of the total pension amount or the pensionary benefits, it does not reflect the order of the Honorable High Court. It just narrates that it is to go to Mr. X or Y. We came to the Honorable Court after waiting for a month or two in January, saying it's not happening. And recently we got the instructions, instructions say we filed the IA, saying that from December 25, the pension is stopped. Although the first wife is getting the pension share.
That's right. First wife is getting because she is holding the triplicate copy of the.
If that is the stand of that, they're releasing everything, that's okay, my lord.
There's no question of stand or no stand. This is what the rules mandate.
Correct.
This order does not reflect how the rules are to be.
But to be absolutely fair,
this order is to be implemented.
But to be absolutely fair,
in the face of the rules.
Being a second wife, I would not have had a right to pension also the earlier, but only because of arrangement
Council,
recorded.
whatever you may say, fact is that the authorities will go by the rules. Either you set aside the rule or you read down the rules. The reading down portion did not come in the order. The rules say pension is to be given to the person whose name is there and who holds the.
But in the event they do not have any difficulty in paying up or they're not taking a contrary stand, they may release me. In the event they're not taking a contrary stand and they're following the orders.
That's what their stand is. I think.
So they need a time period to get back to their stand. If they have the instruction, they spell it out. Of course, we're giving it. Lordship, we close
you can foresee that instruction because that is the rule.
Otherwise,
See,
I am having
a government servant prior to superannuation will
Correct.
put in the papers where the nominees will be there. Now, on the basis of the nominee, if the person dies, expires, then the pension, family pension is released. So the PPO gets divided into three parts: one with the AG, one with the department, one with the person concerned or his legal representative. So if the name is there, you have to show you're alive, you are the person, and the amount gets collected in the credit of the account.
But the present
this is not done by one person. There's a series of process.
But the present difficulty is that if they do not come up with final orders,
the present difficulty is that this order has not read down the rules.
You understand me, Lord. But they have to come up with a stand. Either they are going ahead with the disbursement in.
Lordship, there's the same instruction as the Lordship has.
Please, Your Lordship. I have received the instruction, Your Lordship. Your Lordship, in this order, rule, in this order, Lordship, nowhere mention about the rule 143 of the pension service rule.
Will you get a clarification from the court?
Lordship.
If you are confused, this is an order of the court.
Lordship.
If you think that it is contrary to the rules or there is no mention or you are
Rule
having
143 is not relaxed in this order. Rule 143 is
So
not relaxed. That is why we are confusion arise, Your Lordship.
short of giving you legal advice, your step should be to go and get clarification from the court in terms of this order. Instead of holding on to the order, not knowing what to do.
In the meanwhile, my lord, since my pension part has not been released from December onwards.
Cannot be released in your name unless the rules are read down. Why don't you realize that?
We understand. But since the judgment, the order of the Honorable Court is also not assailed, it holds the field. Therefore, the consequential order may be passed, my lord, even if the release in favor of one.
If you think the order is not complied, file contempt. What can be done?
But today their stand is that they will not comply with that.
Are you aware of a full court judgment of this?
On this no, my lord.
Of this court, full bench judgment in respect to this. Full bench judgment says that under the rule there is a finding there that under the rule it can be only given to one person. So where there are more than one wife or any other claimant, it has to be given that particular person who is nominee of the eligibility. But that does not mean that the person holds it for herself, holds it in trust for the other beneficiaries. And in the event it is not being done, then appropriate action don't have the judgment, but some directions must be given.
Actually, judgment, neither this judgment has been quoted, nor the rule 143.
If you go and file an appeal, review, or clarification, whatever you want. It's an order. This is not an ex-party order, is it? This is an intra-party order.
Inter-party order.
Then Accountant General was represented.
My please, your lordship. Not as per the my lord, judgment, this requisition is not maintainable, my lord.
See, merely because you're a lawyer doesn't mean you'll come and argue whatever you want. Merely because I'm a judge doesn't mean I listen to anything and everything you say. We expect you to make arguments in terms of the law. What kind of arguments are you making? You have not read the order, you have not read the rules. You have a copy of the judgment merely because it has fallen from the court. You want to now thrust it under the court. Of course, I know about this judgment. But this is an order of the court. If you think it has caused hardship, then your step that you should take is to go and file necessary applications either for review or for clarification. Or if you are aggrieved, go in appeal. Of course, you can't go in appeal because it's a consent order.
Consent order. But in these circumstances, if I may pray with all humility, my lord, rather than 40% delay, everything be stayed, my lord. Let us be on the same boat.
Why?
The mother and the second wife are left to lurch where the first wife is getting the care, my lord. I've challenged that. The AG or the government would not be aggrieved with that. Let it be stayed. Let them take a call. Let everyone be at least at peace.
What kind of an order? What kind of a prayer is this?
If the first order was the interim, the 40% be paid to the first wife, I'm praying the entire be stayed or 40%.
Why?
Otherwise,
you'd be more happy if she doesn't get it.
No, it's not about that. It's about that the authorities are now disputing the consent order. We would not even be getting it. The first wife is disputing a consent order. Rather, whatever steps have been taken, let it be stayed. We'll get the clarification if need be. We'll file contempt, get clarification, but let the impute communication be stayed.
First go through the full bench judgment and then
Monday
come back.
Monday,
Tuesday, whenever you want. Monday, have it on Wednesday?
Wednesday.
28th. List on 28th. By the council, the party. Do you understand what is your problem? It is not his problem because all of you have consented before the court that yes, this is what we'll do. You have invited that order from the court. And now you are coming and saying that the rules don't say so. Come back on 28th.
Black.
Yes, what do the records say?
Lordship, yes, after that she did not, and when she has been subsequently appointed, reappointed, she is performing her duty and regularly attending, and she has been paid regularly also.
No, but before her removal.
Yes, Lordship, this is there because this was taken because the earlier instruction it was on that only, Lordship. That after she was terminated, Lordship, they were before this honorable court. So subsequently in 22, subsequently there was an order of December 2014, Lordship, and thereafter there was a direction from the director to the concerned CDPO. But I think this has not been carried out at that time. So when no report was received by the director, again it was sent to the concerned CDPO lordship, and subsequently lordship in this 22 she has been appointed lordship, and she has accepted the appointment lordship. This is there on the last occasion. I produced the written instruction also. On earlier date, I received on because her appointment and subsequently her this things lordship acceptance on the last page. She has not stated that she has been under protest or something like this lordship. And they have not challenged the subsequent appointment also, lordship.
But
Because
she
this-
have been terminated without taking any procedure.
Lordship, there was a statement of the concerned CDPO lordship, because this has come from the director lordship, because at that time the concerned CDPO lordship, there was no record of these things, lordship.
There was no record
Lordship.
of any proceeding, I agree. Right?
Yes,
I'll
lordship.
accept.
Lordship.
But if the person was working,
No, person was not working. This is the statement there, lordship. In today's, yesterday, one instruction that we received, lordship. There it is specific in
it says was terminated
yes.
1811.
Yes.
So termination means she was working at some point in time prior to her termination.
No, lordship. Terminated, she has been terminated from, she is not working there, lordship.
She was terminated from where?
From her post.
Under which ICDS? Under which?
Yes, lordship. Uttar Kodamani. Uttar Kodamani? Yes, lordship.
She was working as what?
She was
As worker, madam.
Anganwadi worker, lordship.
So she was terminated
Yes, lordship.
on 18/11/2014.
14, lordship.
Which means that she was working prior to 18/11.
Yes, yes, lordship. She was there. Subsequently, she has been
Terminated.
Yes, lordship, terminated.
Now she has challenged this termination.
Yes, lordship.
Your officer says there are no records.
Yes, lordship.
Again, how the termination happened.
Lordship, lordship.
Then she was re-engaged.
Re-engaged in 22.
She is claiming her arrears for that.
She hasn't, because these are honorary service, lordship.
Whatever honorary service.
These are honorary service, lordship.
Remuneration is there.
There is no money given.
No,
Yes, yes. There is
this
remuneration.
no money given for the that means for the after the performance of their duty, lordship. So these are completely an honorarium that is offered to them, lordship.
Right, honorarium.
Yes, lordship.
But it's not an honorary service. It's honorarium is. Where is your appointment order?
My lord, appointment order is annexure 1.
Annexure A
Annexure A.
or 1?
Annexure A.
A.
These are all voluntary service, lordship. Anganwadi worker and Anganwadi helper.
At pay is, my lord, 20 vernacular. At that point in time, monthly remuneration was, my lord, 1,000. Now it is 6,000. Subsequently, it was enhanced from time to time.
Yes, yes.
$1,000 per month.
Per month.
She has to be given that amount unless you justify why she was terminated by due process of law. If there are no records, then you'll have to be presumed that whatever her statements are, these are correct.
But she has been newly appointed. She has not challenged lordship. She has accepted her new the appointment lordship, and she has given her joining report also.
Where is the new appointment now?
New appointment lordship. The earlier
I have
one
received a copy. Wait.
of 22 lordship.
Yeah, to the
In one of the instruction dated 1905 lordship.
19.
Yes.
And
Last but one page, Lord.
as your lordship knows, my lord, doctrine of waiver does not have any application as far as right is concerned. What is the question of relinquishment? What is the question of waiver? And there are a number of representation I have received instruction on the very first day, my lord, when stay order was issued, my lord. She approved the authority, she made application, she sought for, my lord, immediate order in terms of the order of the court.
If she has represented that, why she did not bring it before the knowledge of this honorable court's lordship? Why they
No, 1 minute.
lordship?
He was terminated with effect from that 1811.
1811-2014 lordship.
Now that order was directed to be kept suspended by interim order.
Yes, lordship.
Passed on
Of date
17
December 2014 lordship.
Now,
Yes.
From December 2014,
Yes.
she found to be working.
Yes.
She was working.
No, she was not working.
Huh?
After her termination, she was before this honorable court lordship. Then she obtained the order. Thereafter, she represented, and from that means government also communicated with the order of the honorable court lordship. Subsequently, the director asked the concerned CDPO to act according to the direction of this honorable court. So there is a letter also, lordship, of the director addressing the CDPO. But subsequently, lordship, due follow-ups were not, I think, properly, the records are not there, lordship. And thereafter, when no report was received from the concerned CDPO lordship, then again the director returned to the CDPO. And thereafter only, lordship, in 22, she has been newly, freshly appointed lordship.
Where is that? Where is that order of fresh appointment?
Lordship, in 1905-25, this bunch lordship, last but one lordship. And the next page is her joining report. And in her joining report, she has not agitated anything, lordship.
Doctrine of waiver, my lord, does not have.
Kindly let me submit.
For that same thing, correct thing.
You also produce the correct thing. No one is taking advantage. You wanted to try getting advantage.
Hey, wait, don't quarrel.
And here is the reference of this direction of this honorable court lordship in the appointment order.
But how this 22 order can be passed when there is an interim order? The interim order has stayed the termination order.
Yes, lordship, right.
Now, without vacating, how can this order be passed? This
is passed. They have not brought it to the knowledge of this honorable court. She joined. She is receiving her remuneration, whatever is their lordship.
Mr. Purkasto?
My lord, lordship, kindly, first of all, my lord, there is a stay order
they took 7 years time, my lord, to implement the court order. Of course, my lord, there is lapse on my part. At that point in time, my lord, it should have been brought to the notice of the court. There was a lapse. But that doesn't mean that government will be totally exempted from their obligation. Why did they take 7 years time to implement the court's order? And once there is a, my lord, stay order, where is the question of fresh appointment? That apart, my lordship knows, my lord, I don't want to, my lord, apprise your lordship. Doctrine of waiver doesn't have any appearance so far as the right to be considered. And it is a court's order. A vested right is my lord, accrued in my favor. Therefore, where is the question of relinquishment? Since I didn't raise any objection, does it mean that my right will automatically go? And my lord, number of representations are there. There was a direction by the director, you take follow-up action in terms of the court's order, they did not. And unless and until there is some order on the part of the government, my lord, official, how can I join, my lord?
You did not join.
I didn't join. I was not allowed to join because there was no any order passed in terms of the court's order.
You just now submitted that you were not even aware your client had been appointed.
No.
Then how do you make a submission that you are not allowed to join?
No. I made representation. In terms of the court's order, I approach each and every authority, kindly allow me to join in terms of the court's order. It is not that, my lord, I was totally silent or inactive, my lord. And it was brought to the notice of the director. Director issued a direction.
It amounts to flouting the interim order. Interim order is there, staying the termination with the question of.
True, lordship. That's true.
Then
I'm also admitting these things, lordship. But if she has representation, that means she was out of service.
What is the
And representation? There is not a single representation we have found there in the writ petition. There is no representation in the this. Because
sorry, my lord.
this
Sorry.
interim order?
Yes,
Sorry, state of affairs.
Wait, Mr. Professor. This interim order was duly communicated, or at
Yes.
least the matter was before the court.
Yes, lordship. It was communicated.
Presented.
Yes, lordship.
So, in view of the interim order, if she has worked or not worked is a different issue.
Lordship.
But there is no scope for giving her fresh appointment during the currency of the interim order, unless
But
the
this prayer they have not made, lordship.
which
It's
prayer?
this fresh appointment, lordship. This fresh appointment has not been challenged, lordship. They have happily accepted.
Forget about challenging. The order, there is you had passed an
Yes,
termination
lordship.
order that
Yes,
was stayed.
lordship.
Once it is stayed, she is deemed to be in service. So, department is aware of this order, of the stay order.
Lordship.
So, there is no question of the department issuing a fresh order.
Then we have to see, lordship, when the direction was passed, what the officers, what they have done.
Find out.
So this will take time, lordship. And what representation they have, they also put it in record, lordship.
My lord, yes, my lord. My lord, I am sorry to say, my lord, there is an acknowledgement, my lord, issued by the authority.
Acknowledgement will not do. This have to be brought on record, lordship. How shall I know?
I'll bring it on record.
These are issues subsequently to be considered, but there is an interim order, very categorical, and it is included in your instructions also.
Yes, lordship. That I am admitting,
The thing
lordship.
is that you have to tell us whether the department was aware of this interim order passed on 2014.
Yes, lordship. That's why there is a reference of this direction from the director, lordship. There is a mention, lordship, if I am not mistaken, lordship.
Direction
by the director.
Yeah, this was in 2015.
Yes.
Yes, lordship.
2015.
Yes, lordship.
So when they are aware of the order, where is the question of giving a fresh order? Unless you say that this is
Defense of this, lordship. Yes, lordship, definitely. Who has been the official who is responsible for this? Because director has duly forwarded this, lordship.
we are asking you,
Yes.
is this to be read as a fresh appointment order, or is this to be read as an order permitting her to join?
As
The
per
order on the face of it appears that she has been appointed.
appointed, but as per my instruction, lordship, before it is before your lordship, it is a fresh appointment as per their version, lordship.
So you get the instructions that pursuant to the order passed by the courts,
Lordship,
staying the termination order.
Lordship.
What did she approach the authority for joining? And
Yes,
if so, whether she was permitted to join, and if
Lord.
not, why not?
Lord.
These instructions you give us, and we
Lord.
see what orders can be passed. But prima facie, it appears that department, I don't know why.
The department must lordship from director. It is their lordship. 2015 they have communicated, but the
Who has issued the appointment order? The SDP?
the CDPO, TDPO lordship.
Did you file, where is your representation?
My lord, lordship, kindly see, my lord, I received the instruction today morning, my lord. So I am not in a position to bring it on records. I will file an affidavit. I will produce everything, my lord, on 2014 itself, she made an application before the authority, and that was duly, my lord, acknowledged by issuing, my lord, acknowledgement receipt. I will bring it on record. Number of representation, time and again she approached, and all the applications were, my lord, acknowledged by them. Therefore, it is altogether not a correct fact that she did not approve the authority.
In your communication dated 18th of February,
lordship,
from the director,
18
February,
yes, 18th February.
2015,
oh lordship, yes.
from the director.
Yes, from the director there was a communication
That,
intimating the direction of this honorable court and to comply accordingly, lordship.
so
This was their lordship.
there is also a reference that she has filed a representation.
Representation is their
But
lordship.
there is no date
Yes.
or anything mentioned.
Nothing is mentioned,
So
lordship.
you check up from the
Lordship.
record as
Lordship.
to which representation
Lordship.
was in what.
At the same time, some liberty be given to me, my lord, to bring on record.
You bring on record. Matter stands deferred to be listed after 3 weeks, permitting the government council to bring on record.
Lordship, then it will be appropriate
My
if
lord,
they file the
after-
additional affidavit.
Yes, yes.
Then after this, then this will be.
No, you do
Pradhan get the-
independently. He only wants to bring it on record.
Oh,
No,
I'm not
because
filing any additional affidavit, my lord, or just for bringing on records.
yes, the document, so that I can take it up with the authorities, lordship, to get the appropriate direction.
Simultaneously, you can get the
Lordship,
reference of that particular
lordship.
representative.
My lord, may I just make a request to your lordship, my lord? Kindly
Matter
fix the
be
matter
listed.
after 16th, my lord.
Huh?
After 16th of June, my lord.
Yes, will be listed after 3 weeks. On 18th. On 19th. 19th June. By which date the petitioner is permitted to file an additional affidavit to bring on record the representation stated to have been filed. Before the authority
Lordship fixing on 19th.
informing the intimating the department about the interim order dated 17/12/2014 passed by the Red Court. MS M. Bhattacharya, learned senior government advocate, is also permitted to complete her instructions
Lordship.
regard to the any representations, the details, particulars of the representation filed by the petitioner,
Lordship.
stated to have been filed by the petitioner before the competent authority. List record.
I am obliged, your lordship.
Deeply obliged, lord.
List on 19th. 19th June.
I know in this matter, hearing has concluded already. I don't know if to pass the order.
We thought of dictating the order, require some recollection. The essential thing is that you want the direction, the respondent, grant the sanction for utilization of the fund for granting the pay relief.
They have released the amount at one time, my lord, then they did not allow us to, otherwise the benefit of the sixth pay
What
commission
do
from
you
the
say?
beginning.
What do you say regarding a judgment referred to by the Finance Department
Judgment?
of the Supreme Court judgment,
Finance Department.
where they say that where in support of their contention that board employees, as a matter of right, cannot claim pay relief.
That is regarding, my lord, enterprise, public enterprise. But here they have been already, my lord, taken out of the public enterprise. Like APDCL and all, my lord, they will have to do from their own generation. But regarding the board, my lord, they have been given, what is the, my lord, I don't understand, my lord, they, for discriminating for this 7 pay commission benefit. Up to 6 pay benefit they have given. And 2002, they have, my lord, pays 30, I have already stated, my lord. Khadi board is not a public entity.
Today I am not arguing. If it is again fixed for argument, my lord,
arguing, I'm just showing up.
my lord will fix another date, my lord. Today I did not bring any judgment, anything, my lord.
And Odisha High Court judgment I have already given. And the clerks, if I'm allowed to say, my lord, I'll just point out which I have already submitted. That is the impugn judgment, impugn order. Impugn order says you are a public enterprise. Second, you have not given the accounts. So I'm not a public enterprise. They have not applied their mind because 2002 notification has been overlooked. And regarding the accounts, my lord, we have already given account. Board has given account. It is up to date. AG has verified it.
My lord, I think it will be better if we file a written argument, my lord.
I have
It is already filed.
No, my lord, we would also like to file them, a written argument. Amen.
We'll keep it on 27th for passing order. 27th of May.
It has to be judgment, my lord. Ultimately, your lordship will kindly see, they say the matter is pending before the court. My lord, 3 points. If I say, my lord, first they said you are a public entity in the impugn order. Your lordship cannot go beyond the impugn order. Neither they can go because of the Mohandas Singh Gill case. So the second they say, my lord, accounts not given. So that account. And lastly, they say matter is pending before the court. I leave it.
27th.
Okay.
Respondent would like to file. You want to submit anything more?
My lord, 27 will be too short if for
only for submission.
My lord.
What else you want?
My lord. We have already submitted again with 27.